Say on the state, my lord. On behalf of the state, I will be allowed to make a mention. The interpretation has been filed. Urgency is, my lord, in the content proceeding, the unknown saying that is tracing hard. That is the urgency.
So when the contempt proceeding filed?
29.
Long back.
Date fixed is 29. This 29 is a date fixed.
Must have been filed much earlier. Contempt application must have been filed much earlier.
The writ application was filed earlier, but people
No. Give.
I'm a lessee, my lord. Since 2022, I have already, my lord, repudiated the right to more than 1/60, more than 60%, my lord. 2022 till, and also paid more than 3 lakhs for road clearance approach road, my lord. Till today, my lord, I am not by taking land loans. I have already more than 3 years. I am not.
On the slip.
May I current mention, my lord? This matter relates to the compulsory retirement of a district judge. Of the
Compulsory retirement.
Sorry?
Give. Give. Give all the slips.
I beg pardon.
Let us see. Give all the slips. Pass on. Pass on the slips, sir.
Wait, don't wave your memo like that. Please.
Your
Law university, the previous university.
pass on. We will definitely see to it.
To perfect the vending zone in front of the.
Sir, conserve your energy when it is taken up. Exhausted. Give the slip. Let it appear.
Also, but criminal appeal due to non-functioning of previous bench.
Criminal
assigned only listing of the matter.
The criminal not with this bench.
For listing of the matter before the assignments due to.
Please go and mention the matter before the assigned bench, sir.
Lordship, as per their direction, I'm praying before your lordship.
Why?
Okay. अच्छा लिस्ट को रख ली बेटा लिस्ट को चेक दे लो
Assigned bench is available.
Yes, your lordship.
Is then go and mention. And why you are mentioning here?
Yeah. As per the direction.
There is no direction required. If the assigned bench is not functioning, then we can think of. But it is there.
Assigned bench is functioning, then make a mention between the assigned bench.
I beg pardon, my lord. This is, my lord, tender matter, my lord. The date is fixed for tomorrow, my lord.
For opening of the technical bid or a financial bid?
Well, I have not participated because I have filed the
Give. Let us see. Please give and inform the other side if there be any.
Union of India exactly the same situation due to the contempt already I have mentioned. Matter has been that allowed.
Yes, you are under a threat of contempt. We appreciate it. Give.
Transport fee. For warehouse to my destination. My lord, attached similar.
Transport?
Transport fee.
Transport?
Fee. Order attachment. My lord, sir.
Yeah.
My lord, coming from Kolkata, I'm mentioning here again today before the lordship to take up my case and advocate upon by the lordship. I already gave it a memo 27th March.
It will already
given.
So given it will appear. Don't worry.
Kindly look into the matter so that.
Definitely. We are maintaining a roster. Everything is there. We will maintain it. Don't. Yes.
Madam, petition filed for few of the minor garment. WPC.
Pardon to make a mention, my lord.
Yes, sir.
Yes.
My lord, a week before I made a mention before your lordships, and your lordship assured me to inquire the matter as to why it is not getting listed. Read appeal number 2323/24.
Hey, why is it not listening? Please give the memo either or use chat box or give it there. Chat box is there?
Yes, sir.
Please. Please give the number in the chat box, sir. We'll see to it.
Okay, my lord.
Pardon to mention, my lord, I'm in BC, my lord. My
Yes.
lord,
Yes, sir.
Yes, sir.
my lord, from the list, item number 65, my lord, I am
Yes.
praying for an adjournment, my lord. In this
Why?
case, I have to, my lord, in this case, I have to file the counter, my lord. And sorry,
Let us see whether counter is necessary or not, sir. It may not be necessary.
I have applied for the certified copy before the lower court, my lord. So, my 4 weeks time may kindly be granted, my lord.
No, certified copy.
Certified copy.
Sir, let it be called. Just mention at the time of call.
My lord.
Just call the list.
We can. Information item 40 of and for the opposite party, some personal decision that is that we have to.
You are leaving court.
Actually, there is somebody to make a mention.
Yeah, lot of juniors, so just instruct them to remind us.
Pardon to make a mention. System number 20 of election. In training for 2 weeks time election, my learning Mr. SP Mishra has to argue the matter election.
So what? So you argue, you are competent enough to argue. You argue. You are the
arguing matters.
Let us see. Let us see.
Let us see if you
Let it be called. Just wait. Yes.
And the parliament, item number 21.
21 she mentioned.
20.
Oh,
21. I feel it will take 3 weeks after. I need to file an additional affidavit whereby I will need to bring on record the certified copies of the lease deed, supplementary lease deed. So I feel it will take 3 weeks after. So it's fresh admission. Because the issue is they are telling that
why, when you are drafting the appeal, then you should have consulted all those documents. If they are necessary, so you should have.
the company was in liquidation. Now IRP has
It has gone under IBC.
No. IRP was there. IRP has filed it for the company now. The documents were not there. So
Resolution professional has been there.
Yes. He filed this. He has filed this.
Yes, fine.
So I pray 3 weeks time may be granted so that I collect the certified copies and bring it on record by way of additional affidavit.
It's gone to NCLT.
NCLT is there. He has been appointed. Now we are filing that the lease deed should continue. For that the copies are required. I have given the. They are not.
Yes.
6th May.
We are running to item 17 page 20. I have taken consent of Mr. I have to work for the open number 2. I want to file counter. I am not today listed party.
You want to file?
Counter
Why? We'll see. When the matter is called, if the company is really required, then we will consider. Huh?
We may dismiss the appeal. We may not admit it. No?
My lord has a practice state. So, whether secondary evidence or primary evidence.
We'll consider. Please have some patience till we reach that.
On the time of
At the time of call.
Weekly list fresh admission item number 1.
One of the last thing the lordship pointed out is para 10 of the period. Concessional para 10 of the period.
So concession has been made. Then what to do, sir? That judgment I gave you. Have you read that judgment?
I have
You have.
yes,
Ramdas Singh's judgment. The Bank of Bihar.
Bihar still electricity board and others. But I have with me, subject to your lordship's appreciation, and 2 more other decisions. One from this Honorable Court carried to Supreme Court, and another from. In both the cases, the Honorable Appeals Court has said, or in fact distinguished, it has divided into 2 parts: concession on law and.
No, I know. The concession on law is not a concession at all.
Yes, madam.
But a concession on fact is binding on the parties. That's, we are there. Now question was that if something has happened before the judge and if the judge has recorded the event that yes, there was a concession which was given.
My lord, my lord.
So the appellate court should not interfere.
Right.
It is only the remedy is to approach the same judge
Right.
and then invite his attention that this consent has been wrongly recorded. Get a clarification.
Subject to your lordship's appreciation, may I, take 1 minute, my lord. In fact, whatever the concession was sought for was negative by the court. In that paragraph 10, if your lordship kind enough.
Let us see. Let us see.
That appears at page 64, my lord. May I please? At this juncture, Mr. Samantrayal on counsel for petitioner submit that if the court is not inclined to intervene with the motion to be held on 30th November 24, then it should be directed to be subjected to the result of the decision by the opposite party number 2.
With regard to the disqualification pending against some of the members
Right.
who are the signatories of the resolution, the law decided in Ananda Pradhan and response received from such and such for the opposite party as well as Mr. Pradhan. For the opposite party number 12, state the court is of the view the motion is to take place and any such cause of action would arise later to the disqualification to follow accordingly inevitable consequences prescribed under the law. The
I
same thing
give stress upon the
subject to what you say.
I give stress upon section 3 later on to the disqualification in top of decision.
This is what you say, that if they wanted to convene the meeting, then in that event, it will depend upon the decision of disqualification. This is what the court has also said. So
No, my lord. The court has said, however, considering the law decided, my lord, by now it has been decided. It has not.
That is an independent decision. There is no difficulty.
I bow down, my lord.
So it says
once
it's an
independent. So section 24 interpretation is only required. So 26, the petitioner or the person concerned has lost because that is the settled principle of law. Now, so far as section 24 compliance is concerned, that has been dealt under paragraph 9. May I draw your lordship? Peruse the resolution at Annex 2. Short resolution has been signed by the members present at the meeting and by the president on 22nd October. It is prima facie made to appear that the meeting was held on 20th October 2024 and the member as well as the president unanimously agreed to initiate the vote of confidence against the petitioner thereafter. Submit the requisition to the opposite party number 3 upon which the motion was fixed to 30th November 24. The court, considering the submission of Mr. Samantrayal, Lord Counsel for the petitioner, and regard being to heard the resolution dated 22nd October 24, in respect of the meeting held on 20th October 24, and the unanimous decision having lost confidence in the petitioner and therefore to proceed against him as per section 24, no case is made out for interference.
True.
My lord. Now I draw your lordship attention that requisition and resolution, even though it is a part of the petition I have annexed it, I have also independently brought before your lordship at page 20. My lord, first of all, sir, pardon, page 19. The page 19.
Give me the translated.
My lord, translated has already been directed by your lordship and registry has brought on.
My brother will look
registry
into it.
has already brought on record, my lord.
Where?
That is
At
the
flag X.
X.
fact remains there are two mistakes in that error, my lord. In that
Then how
by
can
the
that be relied upon?
by the registry.
Mr.
One date
Das,
they have left out. One date they have left out.
then it is not a true translation, true copy of the.
But it's the registry which was directed, but only a date mentioned on a particular page.
Mr. Das, it is according only.
No, I have to bring your lordship notice.
Yes, that is. Yes, Mr. Das.
I can.
No. Have you read the copy of the translation?
Since I am from Indonesia, that is why I do not require that. But
No.
my friend say that is correct.
Mr. Das,
You
you may not require that. But whether the submission of Mr. Das and counsel for the petitioner Is correct or not? Is correct. It is correct. Correct translation copy has to be. Sir, sir.
Hard line, it is at below. In fact, it is not below.
Therefore, hard line means
The third line of page. Translated. And that member present to the signature.
Signed below.
signed below.
Below. In fact, that is not below.
Then
That is above. That is my senior
that is
above. Not
above.
Yes, my lord. It should not be below.
They have not signed below the content of the letter or
No.
above the content of the letter.
Above.
Yes.
Above. They are signed above.
The resolution, my lord.
My lord may.
That's in the resolution first. The first one is the members present.
Present.
That's the
Yes, that's the procedure.
That's the
Normally
procedure.
adopted. Thereafter, the sentence
that's
starts.
the resolution.
Thereafter, the sentence starts. Of the being today, that is on 20th October 2020.
Correct.
So today, that day it was taken. He is saying that next week, towards the bottom page, is 22nd of October. That is why.
That is what I said, that they have said that it was resolution must have been signed later on because
Yes.
it is prepared. But the meeting
It was
was held
taken
on
on 20th.
20th.
It was taken on 20th, but
No, it's a singular document. Proposed resolution as well as the resolution. A single document.
Sir, in a democratic polity,
My lord.
the majority view is to
To
be
prevail, my
respected.
lord. To
It should
prevail, my lord.
prevail. So now, if the majority has gone, because I have seen paragraph 3 is alarming to me.
And at the bottom of the resolution, none has signed.
We'll say this. That the executive, I do not know, the officer is there. What is the rule here? Resolution taken by this is relating to Panchayat.
Yes, sir. Lord.
In a Gram Panchayat, who conducts the meeting? The executive officer, government nominee?
Sub collector. Sub collector.
That is the government nominee.
Yes, ma'am.
No, Panchayat meeting not to be usually Panchayat executive officer. But he has no complete-
But it is to be convened under the signature of the government official. He is a nominee.
The no confidence motion to be conveyed by the sub collector.
Sub-collector.
So far as this resolution and requisition, it is the 1/3 member. The Panchayat extension officer has
Not
no.
understood, Mr. Sir.
Pardon me.
Who is to convene the meeting?
Convene the sub collector, madam.
This is
No
what-
confidence
that
will be
is-
convened.
No,
Sub collector, madam.
So he has convened the meeting.
But here, one thing your lordship may mark. The requisition, which is the requirement of section 24A, was submitted on 20th October.
Correct. And
And
what
the-
is that? Is there any date given that within that the cooling?
No, my lord. The
24?
resolution has to be passed first and it has to be placed thereafter before the sub collector. Here, it was placed on 20th October, but the resolution, as they claim, passed on 22nd.
no, 22nd, how can it be? Of the
That
day it
bears-
is taken.
That bears the signature and date.
Procedure of them means on 20th.
Where is the law?
My lord, sir,
Where is
section
the law?
20 section
Show us.
24.
Section
24.
of the Odisha Gram Panchayat Acts.
Yes, your lordship.
Yes.
Subsection 211, my lord. In convening the meeting.
Whether the private parties were heard in the writ petition.
No.
Not made party. When made party here. Yes.
What do you say? Where is a violation of section 24?
My lord, the 2A, I am giving straight, my lord. No such meeting. Subsection 2.
Yes.
Clause A. No such meeting shall be conveyed except on a requisition signed by at least 1/3 of the total membership of Gram Panchayat along with a copy of the resolution moved at the meeting. So, but when they are submitting the requisition, it should append with a resolution.
Copy of the resolution.
They have submitted before the sub collector on 20.
What is the meaning of the word resolution here? If a meeting is to be called on a no confidence having shown upon the Pradhan or Sarpanch or a Nayab Sarpanch,
yes, sir.
then in that event it is a meeting which should be convened and then the resolution is to be taken. I think this word resolution which is talked about must be with to an agenda to be there. It should be read as an agenda, not as a resolution. If the meeting is not convened, how can there be a resolution?
But so far as
so this word resolution, I think we have to see whether it is a grammatical mistake or how can it be a resolution? Look at the first subsection 1.
My lord.
Where at the meeting of a Gram Panchayat, especially convened by the subdivisional officer in that behalf, a resolution is passed. It's only after convening the meeting a resolution is passed. And then says supported majority not less than 1/3.
That is the requisite.
2/3 of the total membership of the Gram Panchayat regarding want of confidence in the Sarpanch or Naya Sarpanch. The resolution self-port will be forwarded by the subdivisional to the collector. And then in convening a meeting, please consider under subsection 1 and in the conduct of the business as meeting, the procedure shall be in accordance with such rules as may be prescribed, subject, however, to the following provision, namely, no such meeting shall be except on a requisition signed by at least 1/3 of the total membership, along with a copy of the resolution proposed to be moved. That is what is an agenda. Proposed, because on these are the grounds, blah, blah, blah,
on which we
wanted the meeting to be convened because we are having a no confidence on the Sarpanch or a Nayab Sarpanch. So resolution does not mean the resolution as contemplated in subsection 1.
No, that is the outcome of the.
So if the letter itself, there is no prescribed mode.
No.
Correct.
No.
If the letter itself says that what are the grounds on which we wanted an emergent meeting to be conducted by the subdivisional officer, that itself complies the provisions, because a person should not be condemned unless he is made aware that what point he has to meet. So this is what is the intention of the legislation. You say annexure. No, that there's no. If clarity is coming that what are the grounds, that comes in letter this, paragraph 3, 4.
3, 4. They are subsequent to the meeting held.
These
No,
are the
cannot.
consequence of the meeting.
Where is the
You made
the
to say
letter
that
of 1/3?
resolution means a decision to move a no confidence.
Exactly.
You mean to say.
Yes,
Agenda. That should be an agenda.
agenda. That agenda must affix with the requisition signed by 1/3.
Where is that? That is a sine qua non, 1/3.
Yes.
Where is that 1/3?
So far as number.
Have you said that there was no 1/3?
No. My case is not 1/3 member. My case is that when the requisition was submitted, the proposed resolution or the meeting or the agenda, it was not along with that requisition.
Is it mandatory under the prescribed rules?
It says.
Where is
Your
that?
Lordship, further permission, no such meeting shall be conveyed except on a.
You are talking about copy of the resolution.
My lord. Sorry, my lord.
Copy of the resolution. How you are interpreting it? How you are interpreting this provision? Tell me. No such meeting shall be convened,
My lord.
except on a requisition signed by at least 1/3 of the total membership of the Gram Panchayat. So this is one first ground.
My lord.
Correct? And secondly, with the copy of the resolution proposed to be moved at the meeting. So this copy of the resolution you wanted to say, it should be separately annexed.
Yes. Along with.
As too pedantic and too stricter view you are saying.
My lord, that is what the interpretation.
No, sir. It has to be given a purposive interpretation, not a literal interpretation which you want to say. There should be, what is the purpose? Can you visualize, sir?
Also, your Lordship may have a glance over clause C.
Yes.
Where the subdivision officer on
Requisition. It does not talk about resolution.
My lord, that's why your Lordship may say it is. Pardon, my lord.
No, that is what
That is what is. My lord,
So I'm telling you, sir,
Two projects.
there are two compartments.
My lord.
One is requisition signed by 1/3 members of the Gram Panchayat. First. Second is this resolution means there must be some agenda. That what agenda is to be discussed in the meeting to be called by a subdivisional officer. You say that so far as 1/3 is concerned, we have no, because it was 1/3, requisition by 1/3.
Yes, ma'am.
Correct. Then when you talk about C, means the moment the subdivisional officer receives the requisition, then he has to fix a date, hour, and a time of convening a meeting, which he did in the instant case. Only you are trying to say the resolution must be accompanied, since the resolution was signed on 22nd, not on 28th.
Yes, ma'am.
So this is a prerequisite conditions,
My lord.
and therefore the entire action has to fall. That's a too stricter view, sir. Resolution does not contemplate that.
In fact, that is subject to your Lordship's appreciation.
If there is already a judgment, then
Yes,
subject to my brother
there
agreeing
is
with me,
already judgment, my lord.
subject to my brother agreeing with
Number
me,
of judgments.
I have a dissenting view.
My lord,
Subject to my brother agreeing with
You have to
me.
dissent and prepare and meet the question. It's a place of deliberation. It's a place of deliberation.
No. This is a healthy discussion, sir, on the proposition of law.
This honorable court.
Mr. Das, do you mean to say that the agenda, it is sine qua non, that the agenda should accompany the requisition?
Resolution. He's talking about resolution. The word is used.
Resolution.
And in fact, the resolution is first, then it is to be appended to the requisition to be submitted before the sub-collector.
Mr. Das, you have understood, Honorable Chief Justice. Unless there is an agenda, and a meeting, there cannot be any resolution. The meeting will only be held by, as convened by the sub-collector under clause C.
Well,
okay,
that is
there. So how can that accompany the requisition?
well, that is the requisite, and that has been interpreted by this honorable court.
Where?
the Lordship permits me. The Lordship permits me. The other point what my learned friend addressed.
No, this is the main point, sir.
But dates, he's saying 22nd it was submitted. That is wrong. Because in this calculation of annexure 3, your Lordship.
No, I have seen that the meeting was convened on 28th. We have seen that. There is no difficulty. He's saying that maybe the meeting was convened on 20th. But since the resolution was taken on 20th, resolution must precede the convening of the meeting. This is what his main contention
C
is.
is also, C, clause C is, the entire reading of clause C also throwing some light, my lord.
Yes, sir.
The subdivisional officer on receipt of such requisition shall fix date, hour, place of such meeting and give notice of the same to the members holding the office on the date of such notice, along with a copy of the requisition and of the proposed resolution, at least 15 days notice. So unless it is,
That is the agenda.
my lord, that agenda has been passed on 20th. It was submitted, stated to have been, because it is written that audio, stated to have been passed on 20th.
Yeah.
It was submitted, but that has been signed by 22nd. What I mean to say, my lord, so 22, the requisition has been submitted 20th. But the proposed resolution, that is what C also say, as well as A, that has been signed on 22nd. Moreover, another.
Where is the 22nd signature? Let us see. Propose when the proposed. Let us see whether it is a final resolution or it is.
No.
Let us see.
Page 20 may be seen, my lord.
Page 20. Yes, sir.
Yes, sir.
Is
This
it?
is the requisition.
Oh, so there is already a translated copy. That is the first one, Annexure 2.
My lord.
This is Annexure 2?
Yes, my lord.
Yes.
Your lordship will get nota.
Just 1 minute. What is this NB?
Nota bene says the prescribed resolution is attached.
What does it mean?
My lord, the proposed resolution expressing their.
Annexure 3 is the proposed resolution.
Yes, your lordship.
Page 21.
Yes, ma'am.
Yeah.
Now the page 21 and 22 have been amalgamated into one page.
Correct.
This has been signed on 22nd, madam.
There I differ. It was signed on 20th. I'll prove from the document.
It is your
Proof from
document.
the document, it was signed on 20th.
You have the original?
Original document. Instructors my friend has given.
No, not me. This is the office.
Yes.
Registry. I say.
Do you dispute that?
Yes, from very beginning I say that
No,
this
this-
date has omitted from the.
No. Below, my friend said that in place of below in the third line, it should be above. That's correct.
No. That is there. Adyata Kodia. Mr. Das, it is that if I understood Mr. Das, learned counsel for the petitioner correctly, it is his contention that yes, the proposed resolution was made on 20th. There is no doubt about it.
Yes.
But it was signed on 22nd.
There also I respectfully differ. In the third line, if your lordship sees that in that. Today on 20th October 2024, Sunday morning at 10 a.m., an emergency meeting was held in Pokurpura village under the chairmanship of senior ward member Sri so one of the in presence of the member who had signed above. It at below. My friend said they wrongly typed as below. It should be above. Above all the persons have signed. So that they signed on 20th.
So this resolution was only then how come date of 22nd 10 2024 was
A copy of this document when it was submitted, there he has signed. President had signed on 22nd.
Then how it can.
President had signed on 22nd.
the president was not a party to the proposed resolution.
1/3 members, they have signed above.
Oh.
They have signed above.
Yes, held, my lord.
Subsequently,
Yes, my lord.
On the date fixed.
On the date fixed.
and then you participated there,
Yes, my lord.
and there were loss.
Loss.
Yes, you were a sarpanch.
Yes, my lord.
Then
My lord, even
Why you
there,
did not raise that
That-
at the time of the meeting conducted by the sub-divisional officer? When it was, notice was given to all of you, including you.
yes, my lord.
Why you did not raise immediately objection that, look, this resolution is signed by 22nd, meeting is held
But I-
on 20th. Why did you write any letter to a sub-divisional officer immediately before participating in that meeting?
Okay, after this order passed by this honorable court, this was held, my lord. The no competence. So in view of this order or judgment, thereafter writing by me,
No,
No.
meeting was conducted on the date fixed.
date fixed,
when
30th November, my lord.
30th November.
My lord.
And you approached the court.
Court.
And prior to that, I have approved,
No, when the order.
my lord. Just
Sorry.
a moment, my lord. I have approached on 14th/11, my lord. And this impugned order of the
28th
honorable
28th of
28th,
November.
2 days thereafter, meeting was. And there are number of decisions, my lord. This honorable court, while exercising the interpretive jurisdiction, has set aside the all consequences.
Mr. Das, with Sabhapati.
There are.
Sabhapati who signed.
Mandara Sabha.
Huh?
Mandara Sabha.
Mandar Sabhapati means who is in a Gram Panchayat, any president is there?
Very well, I couldn't do.
No, the resolution, you said that only the proposed resolution was signed by the president on 22nd.
On 22nd,
Who is he or she?
sorry, my lord. On 20th also he signed. Your lordship will find his name at the top. On 20th, when the decision was taken, he was among the
Then
signatories.
what was the occasion to sign it again on 22nd?
So at the time of submitting there, your lordship, for a moment, possibly I couldn't express properly. But your lordship, kindly see the page 21 of the writ.
Yeah. Writ of appeal.
English translation has been given now. At the
Okay.
top, your lordship will find.
Annexure 3.
Annexure 3.
At the top, your lordship will find Mandar Sabar. All these 11 persons, they signed on 20th.
Yes.
Lastly, at the bottom, while giving a copy, he has signed it on 22nd. So that cannot be treated to be the date of signature. Date of signature is 20th.
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 Yes, Mr.
Well, it specifically said under the NB nota bene that the prescribed resolution is attached on the next page. A copy of the same is forwarded to the district collector.
It was only forwarded under the signature.
And that date is 20th, my lord.
Yes, the resolution was taken on 20th.
No. This is the requisition of this is the.
That requisition.
Sorry, my lord. This is the sub collectors before whom the requisition has been submitted. This is 20th. How can they say that we are filing the proposed resolution of 22nd along with this? Probably, lordship, page 20 may.
Page 20.
Yes, your lordship.
Yes.
Or else the translated paper.
Come to annexure. This date is wrong according to you.
Yes, my lord.
What a date.
To the sub-district collector, you will find annexure 2 you are talking about.
Yes.
What is the date?
20th October 2024.
No.
Here in English translation is 22nd.
22nd.
My lord, 22nd in the top. That is an endorsement date of the officer. This is not the date of submission.
What are you talking about?
Yes, my lord. Your lordship,
What are you talking
it bears a memo number 2528/22. But they themselves who has submitted, those who have submitted, they have given the date on 22nd. Sorry, pardon, my lord. 20th of October.
So the annexure 2.
And
Mr. Das,
pardon.
annexure 2
My lord.
is the letter. Yes, 25th/22.
2528/22. 22. That is their official memo.
2528. I'm sorry.
That is the official memo number. That is,
So it is issued on 22nd.
no, that was the internal communication.
What internal communication, sir? It is the requisition.
No. That 2528 is the official sub-collector's office number, my lord. Memo number.
It's 20. But it was
No, my lord. They have given the date 20th. Your lordship, very clear and bold, my lord.
where?
My lord, page 20, below the Bishasa Drashtavya Tale Dekhontu again.
Yes, it is 28.
My lord.
But it was submitted on by memo number 2825 dated 22nd.
My lord, this memo is the intra-party,
What intra-party?
intra-department memo
What
number.
intra-department?
We have the neither the requisitionist.
GP section.
Exactly, that is why that
GP section received it on 22nd.
My lord, that is the GPCC from the sub-collector with the memo number. But it was submitted before the sub-collector on 20th.
No.
Take instruction.
Mr. Das.
And curiously, the meeting conveying notice doesn't speak of the date when the requisition.
Mr. Das, you are stretching it too far.
If you show us the decision, let us see.
Let us see.
What has been decided on the proposition of law.
Proposition of law that
On
it is
on a factual note.
Rules are required to be followed. No judgment says rules are required to be followed.
Who denies whether that is what is statutory rules, so it has to be followed. Show us the decision.
Yes, Mr. Das. Which paragraph?
paragraph 6 at 5. The question has been framed.
Yes.
That whether the learned signature is justified passing the notice number such and such issued by the sub-collector court facing the date, no confidence of motion, meeting against respondent number 2 on the ground that no results required 24(2)(a) of the GP Act has been sent to the sub-collector along with the requisition, particularly when no such ground was taken. This is how, but while discussing that, paragraph 6, this honorable court said, so far the issue number 1 concern, undisputedly the present case requisition has not taken all those grounds, but that is the requirement 1, 2, 3, they have categorized. Thereafter, my lord, another reason, in fact, this would throw more light on the point I have canvassing. This is also, I am not citing the single bench decision, not necessary. It's a interpretation of parametria provision of Panchayat
Odisha Jilla Parishad.
Jilla Parishad, madam.
Yes.
The second page of the
Yes.
that ABC, that the 39(2) has been quoted, my lord. And page 69, paragraph starts with a close reading, a close and careful reading.
Yes. At the top.
Yes, your lordship.
Left hand column at the top. Jilla Parishad Act.
You are relying on Ananda Pradhan.
Yes, madam. Which has said that 26 has no bearing.
I will agree with that.
No bearing. With regard to concession, with regard to that concession more particularly, madam.
judgment of AIR 2001.
Page 67.
67.
My lord.
On what proposition?
My lord, issue was a no confidence motion under a parliamentary provision under section 39(2).
Of Jilla Parishad Act.
My lord. Here the only difference is date of notice. It is as it is. Here it is 15 days, there it is 7 days.
7 days notice. In Jilla Parishad, 7 days notice.
My-
Short notice.
Short notice.
Short notice.
Here it is not a case of short notice.
No, not at all. But page 69, your lordship kind enough.
Yeah.
The paragraph starts with a close and careful reading of the aforesaid would show that before convening the special meeting for recording want of confidence in the president or the vice president of Parishad, it should be prepared by a requisition to be addressed to the RDC, Revenue Divisional Commissioner, and by at least 1/3 of the member with right to vote. The requisition is required to be accompanied with a copy of the resolution proposed to be moved at the meeting. And the receipt of this, I give stress upon this part.
So it was, there is no dispute that it was not accompanied with a copy. One thing is that it was signed on 22nd, not on 20th. So there was no resolution on 20th.
My lord. That is my
What's your
point.
point?
That is my point, my lord.
Yes. Anything more?
And moreover, well, here, one thing subject to your lordship's appreciation, at the threshold it has been disposed of. There has been no cross-check with regard to a particular allegation by a elected member. Seated sarpanch. We have been directly elected. Question of your lordship has rightly said that majority will always prevail. So far as confidence, because the ward members are also directly elected. So do the sarpanch have been directly elected. Now, rules, of course, there is no rules. Though section 24 refers about rules. Sorry, there is no rules. So far as this conduct, section 24 reference rules is not there. But the section 24 itself is a self-contained and it has provided or prescribed procedures to be followed. As I pointed out before your lordship in that decision, a 2001 decision, it should preceded by a resolution. Now, question, in fact, your lordship has cornered me to a point that to satisfy at least on one aspect, that it was submitted on 20th, not 22nd, as it reflects from out of the translated copy, or it is urged by my lord senior. I have to satisfy. This is the factual aspect, my lord. But question is, from out of page 19, 20, and 21, I demonstrated in clear terms, it was submitted on 20th, even assuming that that proposed resolution has been annexed to it. Then also, it was signed by on 22nd. The second question, my lord, it should be signed by 1/3. This question, it involves two assets, my lord.
Mr. Das, you don't have any objection to that. Now don't raise that issue again.
No, I am not raising about the number, my lord. I'm well conscious. I will not touch upon that, my lord. Touch upon. Because I have not raised that question.
Your point that section 24(2)(a) prescribe a mandatory procedure that the letter or must contain the resolution, a copy of the resolution. And therefore, the copy of the resolution appears to have been taken on 22nd, not on 20th when the meeting was there. Unless the meeting was there.
Requisition submitted.
Whatever, unless meeting was. So in that event, it is not in proper form or in a proper manner. And therefore, the entire thing, because if the foundation is removed, then whatever the structure which is there, that will also fall. That is what your case is. Even if the meeting is finally convened on 30th in terms of the order, but if this you succeed on this point, let us see that there was any violation of those provisions and what that provision means and what correct way of understanding those provisions. I think that is your argument, nothing more than that. So why you? So just permit us 2 minutes time to dictate.
No mother would like to see. Brief is a child.
That's, I was there for nearly 90 years, so I know.
In that event, it is too awkward for even for me also. One thing, my lord.
It's a very healthy discussion. On the
One thing.
proposition of law.
Would your lordship, my lord, would your lordship, not mine, to allow me one day time to bring all the decisions decided,
This is you have already relied upon.
In fact, my lord, it will helpful for bar also, my lord. What is that? It has been divided into 3 parts, whereas it is 4 parts.
Mr. Counsel, the difficulty is because I believe is that interaction on the proposition of law is a very healthy one for both the sides.
In that event, my full discharge would be.
It brings a more fairness and a transparency in the decision-making process. But if it is taken as a ground for an adjournment, then I think then
Never. That's why I said. No.
And then you finish the argument. And
by doing that, I am using the X on my leg.
Learning and we are exchanging our views on that.
By adjourning the matter, I am using the X on my leg because the process of election may take at any moment, even if not till today, but within 3-4 days, fresh election. It has been declared vacant.
It is not a matter of concern here.
Now, Mr. Das,
There are procedures.
Naib Sarpanch will be in charge. Immediately he will be kept in charge.
So far as fresh election of the Sarpanch, the state has already taken a decision. They are going to notify by
the law.
Yes, my lord. Not for this. 1147 posts. So it's not that for me only. And asking for
What improvement you can make? Your facts are undisputed.
Facts are undisputed.
The law, applicability of law is also uncertain. Is certain.
But I would not like to add any foreign submission.
Then what
But one thing, on the requisite of again, that signature of one person, that is also my specific ground. This doesn't fulfill the requisite of 24(2)(a).
Let us see. That's that the resolution is still there.
My lord.
So, no, annexure 2 and annexure 3. These are the 2 things.
My lord.
You are relying on.
My lord.
No problem.
My lord, here it's.
The 3 is 11 and this 9.
I think, would your lordship, tomorrow?
No.
I think I will not be.
No, you have.
I'll not be Tom as careful towards my class.
What?
No. One more thing. Because that point I have to satisfy. The signature of one person doesn't fulfill the requisites of signature of all.
Don't worry. That will also be taken into account. Actually, whether it is correct or actually it is not correct.
I think.
Because the documents are still there, annexure 2 and annexure 3.
In the process, I think my writ appeal may not see the sunrise.
Why you anticipate something? We have not taken a final decision.
In that process, we have reached the noon. Why are you thinking of sunrise?
So that's what only on that score. Whether it amounts.
We have the original annexure 2 and 3 with us. No difficulty. You are taking annexure 3 is signed by only one.
Only one.
No difficulty. No difficulty.
If it is in.
Well, take into consideration. That is there.
But I think I can address and satisfy your lordship.
What for?
That one signature is not the requisite of 24(2)(a).
Mr. Das, satisfaction is ours. And your is only persuasion.
I will try to satisfy.
Persuade.
That is what among the Transgressing.
I will try to satisfy.
Okay.
Nothing more. Nothing more.
We are satisfied with your
Let this printer, let
very
this,
nicely.
my lord,
Very
let
nicely.
this printer run at its peak, my lord.
What?
By allowing tomorrow, let this printer run at its peak.
Please.
Thereafter, your lordship can use this stopwatch to declare me.
No.
We should not. I don't believe in that.
That on that score,
That is
only one day.
No, not required, mister. Please.
the judgment and order of the single bill received in the instance in an intercourt appeal. On two grounds. Firstly, the resolution taken in the meeting held on the requisition of 1/3 members of the Gram Panchayat here's the date, that is 22nd October, 27th October 2024. Although of the requisition of the meeting, it is to have been held was 28th October 2024. Secondly, the the letter issued to the subdivisional officers under section 24 of the Orissa Gram Panchayat Act 1964 does not accompany the resolution which was admittedly taken on 22nd October 2024. And therefore, the entire decision taken thereupon is directly in contravention to the provisions contained in the aforementioned act. Before we proceed to decide the aforesaid two legal points canvassed before us, a prelude to the litigation is required to be adumbrated Where is your red petition?
Annex of 3, Annex of 4.
4.
Yes.
Page 23.
Page 23.
Pursuant to the general election of Sarpanch held in the year 2022. Yes. You have said general elections, so I am just borrowing that from
That is how the.
it cannot be in paragraph 3 cents.
I've seen, my lord. I've seen.
The election for Sarpanch held in the year 2024. The petitioner was elected as a Sarpanch of Garinggaon GP under Kalahandi district. And since thereafter, continue to discharge the duties entrusted upon him, both under the law and by the purpose of the said Gram Panchayat. Subsequently, some of the members subsequently, on the basis of the allegations having made against some of the members of the same one was conducted under the Orissa Gram Panchayat Union Bracket Amendment Act 1994 with regard to their disqualification. Subsequently, the petitioner communicated to the district panchayat officer the complaint against the members, some of the members of the state Gram Panchayat, including that some of them are not attending the meeting since last 3 months. Stop. Next, amidst the pendency of such decision for disqualification of some of the members, they received a notice plus letter dated 11/11/2024 issued by the sub-collector, which contained the letter slash requisition dated 20th October 2024. Issued by some of the ward members, along with the resolution, alleged to have been passed on 22nd October 2024. To the effect that a special meeting would be held on 30th November 2024 at 11 AM in Gram Panchayat Conference Hall for consideration of an agenda pertaining to a no confidence having mooted against the appellant. Immediately after receiving the said notice, the approach was made to this court impugning the letter of the official communicating the date, time, and the place of convening the meeting on the resolution taken by some of the members of the said Gram Panchayat, flagging an issue of no confidence against the appellant. The said writ petition was initially entertained, and by the impugned order, disposed of with the following observations. Please quote that the last operative portion.
9 and 10.
9 and 10. 9 and 10.
Please, paragraph 9. I'm going to appearing for the appellant. Audaciously that the documents, the annexure 2 and 3 to the writ petition would manifestly indicate that there was no resolution taken on 20th October 2024, as the resolution bears the date of 22nd October 2024, and therefore there is a clear vision of the provisions contained under section 24 of the said Act. Mr. Das would further submit that the law mandates the annexation of the resolution along with the meeting, along with the notice, inviting the attention, inviting the meeting to be held and conducted by the sub-divisional officer, which apparently does not appear to have been followed, which would be evident from the fact that the resolution bears the date, that is 22nd October 2024. Mr. Das vociferously submits that the notice to the sub-divisional officer issued by the president is also infirm and not in consonance with the statutory provision, having signed by a single person and not by all the persons who requisitioned for convening a meeting, and therefore the moment the is found to be illegal, all consequential steps taken thereupon would also liable to be cause. I think we have taken all your points. Next paragraph. Per contra, us the learned additional government advocate refuted the contention of the appellant that there is any departure from the statutory provisions. Rather, it is submitted that the resolution was annexed to the notice issued by the requisitionist to the sub-divisional officer, and therefore the contention of the is factually incorrect. Mr. Das vehemently submits that the resolution was taken on the date of the meeting having convened by the requisitionist, that is 20th October 2024, And the resolution gives us a date, that is 22nd October 2024, but is a decision taken in a meeting held on 20th October 2024, and therefore it complies the requirements contemplated under section 24 of the said act. Thus, would further submit that the President forwarded the letter containing the resolution taken by the requisitionist on 28th October 2024, which is also in conformity with the statutory requirements. On the prospectus of the aforesaid stands having taken by the respective councils, the points which emerge in the instant case as succinctly quoted in the opening paragraph of the instant judgment are required to be decided on the parameters of the law applicable in this regard. It would be apposite and profitable to quote the relevant provisions, that is section 24 of the Odisha Gram Panchayats Act 1964, before we venture to decide the aforesaid quote that provision, section 24. On a meaningful reading of the provisions contained in the above referred sections, it is manifest therefrom that where a meeting of a Gram Panchayat is convened by the sub-divisional officer and a resolution is taken with the majority of 2/3 of the total membership of the total members, with regard to the no confidence in the Sarpanch, the resolution shall forthwith be forwarded to the collector, who shall immediately on receipt of the resolution publish the same on the notice board. And from the date of such publication, the Sarpanch holding an office can be deemed to have been disqualified and vacated the same. Subsection 2 of section 24 is a self-contained court by itself, as we are informed that there is no prescribed mode of convening a meeting, notified by the government. The emphasis is put to AC of subsection 2 of section 24 of the said act, mandating the meeting to be convened on the requisition signed by at least 1/3 members of the Gram Panchayat, along with a copy of the resolution proposed to be moved in the meeting. And on such requisitions having received, it is the subdivisional officer to fix the date, hour, and place of such meeting, and serve a notice upon all the members holding the office on the date of such proposed meeting, on the date of such notice, together with a copy of the resolution and of proposed resolution, together with a copy of the requisition and of the which should not be short of 15 days from the date so fixed. Subsection 1 of Subsection 1 of section 24 envisages two situations. Firstly, the resolution must be passed in a meeting of a Gram Panchayat convened by the subdivisional officer with a majority of 2/3 members. And secondly, such resolution must be forwarded to the collector, who shall thereafter affix the same on the notice board and from the date of such publication in the notice board, the Sarpanch would be deemed to have vacated the office. As indicated here above, subsection 2 of section 24 is not prescribe the procedures of convening the said meeting. And the moment the legislation has incorporated the same in a statutory provision, the same has to be adhered to as a decision or the action taken by the authorities in contravention thereto would entail such decision liable to be struck down. we are not unmindful of somewhat second proposition that the moment a thing is required to be done in a particular manner, the same should be done in such manner. What is contemplated in subsection 2 of section 24, that no meeting could be convened unless one-third members of the one-third of the total members of the Gram Panchayat signed the requisition, and a copy of the resolution proposed to be moved at the meeting to be called by the sub-divisional officer must accompany the same. What is sine qua non in this regard is that the no confidence motion can be brought by at least one-third members of the Gram Panchayat, and the requisition of convening the meeting with the proposed resolution, or in the event the meeting is convened, the resolution adopted therein must be served upon the sub-divisional officer in order to call the meeting of all the members of the Gram Panchayat. It is not in this, factually we do not find any dispute with regard to the requisition by one-third members of the Gram Panchayat. At least the appellant has also not taken such point or pleaded. And therefore, we can safely proceed on the basis that the requisition was made by one-third members of the Gram Panchayat, flagging an issue of no confidence against the Sarpanch. The dispute hinges on the resolution taken in the meeting of the one-third members who have signed the the requisition. Whether such a resolution was adopted on a date when the meeting was convened or subsequent thereto. It is manifest, it is evident from the letter issued to the sub-divisional as collector, Bhavani Patna, Talahandi. The same is signed by all the requisitionists, and the resolution, the prescribed resolution is attached on the next page. It is on the next page. Here's a date, that is 22nd October 2024. But the said letter was issued on 20th October, signed by 11 members of the said Gram Panchayat, with a clear note that the copy of the resolution is attached in the next page, and the same is being forwarded to the district collector. It is thought to be contended by the appellate that though it bears a date that is 22nd October 2024 at the top corner of the page on the right hand side, but it has no bearing to the date of issuance of the said notice, which would further be corroborated by the fact that the resolution was signed on 22nd October 2024. We are unable to accede to such submission for the simple reason that admittedly the meeting was held on 20th October 2024, and the resolution was taken, which would further which would be corroborated by a subsequent letter annexed to the petition as annexure 3. It is inconceivable that a resolution would be taken on earlier dates and not on the date of convening the meeting. Even the petitioner has not made out any case that the meeting was not held on 20th October 2024, but on a subsequent date. And therefore, it is improbable that the meeting which was admittedly held on 20th October 2024 ended without taking any resolution. There is no better in signing the resolution on a posterior date, as it simply ratifies and signifies this decision taken on the date of the meeting. And therefore, it does not invalidate the notice or the resolution under section 24 of the said Act. The moment the notice is accompanied by a resolution, it fulfills the conditions enshrined in the statutory provision. Such compliance has to be interpreted in a pragmatic manner. Stop. We are unable to comprehend the contention of the appellant that the copy of the resolution the expression copy of the resolution appearing in the aforementioned statutory provision is to be interpreted in a sense that it should be a part of an annexure to the notice / requisition. In other words, such a resolution must be recorded in a separate piece of paper and to accompany along with the notice. The purpose of the resolution having taken in the meeting to be accompanied with the copy of the notice is to make known to all the members that the meeting would be held and the discussion shall be made on the agenda or the decision taken by the requisitionist in an earlier meeting pertaining to a no confidence against the Sarpanch. Such procedure is to ensure the fairness, the transparency, and the meaningful discussions to be made on the proposed agenda of the resolution, and none of the members should be put on surprise on the date of such meeting. The purpose is laudable as the authority convening the meeting has to ensure not only the strict compliance thereof, but also ensure, but also secure the equal participation of the members in the meaningful discussion in the proposed meeting. Any other, there is no prescribed mode as of now that such a resolution must be transcribed in the separate sheet as the interpretation thought to be made by the appellant, if accepted, would frustrate the legislative intent and would the provisions relating thereto. The court must adopt such interpretation which would further the workability of the provisions than to render such provision osseous or redundant. The court must harmonize the different provisions of the statute to make it workable, unless the court finds such provision irreconcilable we do not find any discord between the steps taken by the authority with the spirit of the statutory provisions appearing under section 24 of the said act. We had been taken to the requisitions as well as the copy of the resolution annexed to the petition, as well as in an application for stay filed before us. We find that the copy of the resolution was attached on the next page, and therefore satisfies the conditions enshrined in section 24 within bracket 2 within bracket A of the said act. Stop. We thus do not find any justification in the stand of the appellant in this regard. So far as the second point urged before us, that such requisition was signed singularly by the president and not by all the members, we do not find any substance or the same to be factually correct. Annexure 3 Annexure 3 would reveal that the meeting was held on 20th October 2024 and a resolution was taken, and such communication was made by the president in presence of the members who held such meeting and duly signed therein. Such document on its such document on the face of it cannot be construed to have been signed only by the president, but by all the members who were present and convened the meeting on the said date, as they put signatures across their respective names before the proposed resolution taken in the said meeting. The procedure is a handmaid of justice, and to be considered in such perspective, in absence of any prescribed form, the court must look into the document as a whole And if it appears that all the members present and all the members present have put their signatures on the said document, merely the president having signed at the bottom does not render such document to have been issued unilaterally by the said, but must be construed to have been signed by all who called who requisitioned the meeting and fulfill the criteria of the statutory provisions. On both the counts, we do not find that the decision of the single bench warrants interference. The appeal is thus dismissed. So also the applications connected. So I have taken all your points.
Yes, yes.
Can't say that.
No.
Item number 2.
May I please, Your Lordship? The village forest land being forcibly occupied with the private opportunity 8 and 9, Your Lordship. The last occasion the state has taken time to obtain any taken regarding eviction, Your Lordship. The state has to clarify regarding the action, Your Lordship.
Here we have filed an affidavit on the 11th. Perhaps that has not come on my lord's board. Your lordship may kindly have a glance to this affidavit. Encroachment proceedings have already been initiated against the
You have already initiated.
Yes.
What have you served a copy of him?
A copy has not been served to me, Your Lordship.
Because he is online and it was filed.
Online today I am appearing. On that day I was appearing physically, and earlier my associates are there also.
The affidavit was prepared on 11. So
correct.
It cannot be served because of
So why don't you serve a copy?
I'll serve.
Is that all the steps has already been taken for removal of those encroachers, which is your primary object.
But there is no they have to evict. My endeavor is they have to evict.
Sir, if they have initiated a proceedings, then that proceeding must be brought to its conclusion.
Yes.
They will bring it.
Sometime also what is happening, the Tahsildar Your Lordship simply Your Lordship initiating the proceeding, finding affidavit, then remaining silent over the matter, Your Lordship.
There is a statutory requirement. Then what can be done at this stage?
Your Lordship, may dispose of my repeat. Shall I pray one thing, Your Lordship?
Why you have to be reminded? That is his grievance. When he came and reminded them, then
thereafter these things.
Right.
And what is the status of those proceedings?
Proceedings have been initiated
already.
Very recently it has been initiated.
Mr. Das,
because
very often it is seen that after initiation of the proceeding, they become dormant. No steps are being taken. Only because intervention of the court you might have initiated or you might be proceeding. Once it is disposed of, you will not take any step. And the things will remain as it is.
But here, on the basis of the allegations received from the villagers, the G form was registered, encroachment proceeding, and the encroachers have already been put to notice.
So when? Only after filing this writ petition.
Just a minute, Mr. Jana. Mr. Jana, please have patience. Please have patience. So what? Whether you have stated in the affidavit,
yes,
what time it would take to complete the proceeding?
Because
there is statutory period for completion of the proceeding.
Yes.
Whether it is complete or not.
But it is statutory.
It is under the OPL Act.
OPL Act.
OPL Act.
There are also provisions of appeal and
forget that.
Yes.
That we are not on appeal. But we have initiated proceedings under Section 7 of the OPL Act. All right. What is the status and how long it will take for disposal of the proceedings? Have you stated in the affidavit?
Yes, ma'am.
Yes, so.
Your Lordship may kindly see para 8. Para 8.
Para 8, you simply say that you have issued a notice.
The entire case record I have.
C6, you have the next.
C6 is the entire encroachment case record.
Page
8. 8. That is the case record. The coffer and the coffer both
Your lordship will find
What?
your lordship may kindly.
How can Mr. Das, you know, form call cannot be issued simultaneously?
It has not been issued simultaneously. It has been issued. Your lordship may kindly.
Then call form, if it is issued,
Yes.
then it is an order of eviction.
Yes.
Where is that?
Your lordship.
Where is that call form?
Call form is at page. That is at page 14.
Page 14.
Yes.
When it was issued?
14/8/2024.
Yes. Have they been evicted? Bedakal kari diya jibo.
Yes.
Bedakal means they will be dispossessed. So since August 2024, admittedly you have not evicted. That's what we are saying.
Not evicted. My lord may kindly have a glance to page 16.
Yes.
You have fixed the date for hearing that.
द्वारा तुमको सूचित करा दिया जाउची जे निम्न राजस्व इत्यादि बकाया राशि.
That is a penalty.
That is the penalty.
Yes.
So you have not.
The entire eviction proceeding has not been completed. It will.
No, Mr.
You have fixed
Das.
the date, I believe. What is that?
12.
20th, what?
No, that is the date of hearing.
That is what I wanted, 20th?
That is 10.
10/3/25.
10/3/25.
Yes.
Now it is over.
That is over. My lord.
So it is the affidavit is filed on 11/4, 1 month after, and you have not stated the up to date status.
The final eviction process has not been completed.
But you have imposed penalty only
Yes.
for their occupation.
Yes.
This should be evicted. Why penalty?
The eviction process has to be completed within a short span of time. So exact the exact
Mr.
period
Das,
they have
it is-
not.
It is not a complete affidavit. We don't appreciate. Who was
signed by the Tahsildar.
Who is the competent authority to initiate the proceeding under OPLEA?
That is OPLE Act, the Tahsildar.
OPLEA.
Tahsildar. And he has filed this affidavit.
So eviction, you are really appears to us misdirect. You are really chasing them for a penalty, realization of the penalty to encroach upon the government land, nor instead of evicting them from the government.
First, the process for assessment of penalty is done as per CORAM. After CORAM, that realization of that penalty, then the
No, Mr. Das, it is not.
This is really a putting a cart before the horse.
Exactly, sir.
Sir, first you evict them.
Then realize.
Chase them for penalty for the occupation which they were there on a wrongfully on your land. You will first ascertain that you are already there in a wrongful occupation. Pay me, and then I will evict you.
Well, you may kindly see section 4 of the Act.
Let us see
OPL Act. What is the Prevention of Land Encroachment Act? Yes.
Section 4.
Section 4.
Yes.
Levy of assessment of land unauthorizedly occupied.
That will
Any person unauthorizedly, which is the property of the government, shall be liable to pay by way of assessment. 1. If the land so occupied was at any time assessed to rent, the full assessment for whole of the period. That is the provision. Then your lordship may kindly see the proviso. Provided that where the person unauthorized was, such land is a landless person, the amount payable by him by way of assessment, and this process goes on. Then you will
landless person. That qualification has to be how you will ascertain they are landless or they are not landless.
That is a proviso. But first the assessment is done.
No.
Then you will also kindly come to 7.
What is the eviction provision?
Section 7. Read section 7. You have not initiated any proceeding. as it appears.
Your Lordship may kindly see section 7.
Yes, please.
Any person unauthorizedly occupying the land for which he is liable to pay assessment under section 4 shall be summarily evicted by the Tahsildar, and any crop or other product raised on the land, any encroachment such as building, other construction or anything deposited thereon shall be liable to forfeiture, provided that in case of the said encroachment, the Tahsildar shall give reasonable notice to remove the same.
Correct.
Notwithstanding anything contained in subsection 1, where the land is in unauthorized occupation of landless person, the Tahsildar may, instead of evicting such person from the land in his authorized occupation, settle the same with him. So, however, the land so settled with him together with the land, excluding with respect to the settlement, if any owned by him, and the lands owned by all the members of the family who are living with him in common mess, shall on no account exceed one standard acre.
That's the standard that it does not exceed.
Yes.
Very interesting words has found in this. Where any land is in unauthorized occupation of a person, landless person. The Tahsildar may, in a state of evicting such person from the land in his authorized occupation. If he is an unauthorized occupant, then under the authorized occupation.
How can that be authorized occupation?
Then
this will be authorized if you settle it.
Settle it.
Yes.
If you do, so long you do not settle, he remains an unauthorized occupant.
But so far as settlement is concerned, 8A is the provision.
That is a different thing. If they apply for under section 8A,
that is more than 30 years.
There are two aspects. It is not dependent upon section 4.
Yes.
As you sought to say. Section 7 is independent. It says that you have to summarily remove him from the occupation, and then he will be liable to pay the
compensation under section 4. Oh, yes.
Only exception is if he is a landless person, then the Tahsildar will make an extensive inquiry, and if it is found that he is a landless, then he can settle it. But he'll have to initiate a proceeding under section 7 immediately.
That proceeding has been initiated.
But you are not taking any steps, sir. That's all I'm saying from the very beginning.
But for that purpose, so-called notices have been issued to the
sir. Form Form in the schedule. What is that? It is a notice for eviction. They should be evicted immediately. But still you are continuing with the eviction proceeding. For me, it is for me.
Issue a notice under Form B.
Yes, that has been issued, sir. Then you are not evicting.
But the how far we are may kindly see.
Yes.
How far?
Yes.
It's ଆପଣ the notice 30 ଦିନ ମଧ୍ୟରେ ଅବରୋଧ କରିଥିବା ପ୍ରକୃତ ଜମିରୁ ଅପସରି ନଗଲେ ଆପଣଙ୍କୁ ଉକ୍ତ ଜମିରୁ ସମ୍ପୂର୍ଣ୍ଣ ରୂପେ ବେଦଖଲ କରିଦିଆଯିବ. That is what the notice has been issued.
Yes.
So it has not finally taken the shape.
Yes. So that's what we are saying.
Bedakhal koriyajibo means will be evicted.
Will be evicted.
So what does it mean? I understand. Don't worry.
No other steps can be taken except evicting them.
Yes.
Throw them out.
Throw them out. file affidavit.
If they are lenders, then lenders, we can't wait that you will permit those government land to be enclosed. And this is coming under the forest land. Recorded.
Yes.
Then how can you? If you can't.
Still can't do it.
Grant me some time so that I can file a fresh affidavit with eviction.
Or sir, this matter is pending for a pretty long time, 2024. And
2024.
issue. I think you are to be reminded of your rights, your powers, your jurisdiction. I think that is the only purpose of this. In stricto sensu, PIL does not lie. If we go by a strict parameters of the PIL, then I think definitely this PIL has to go.
File a fresh affidavit.
First you serve this affidavit on him, you have not served.
Affidavit dated 11/4/2025, filed by the Tahsildar Badasahi, is taken on record. Copy of the same be served on Mr. Zainal and at counsel for the petitioner when? By tomorrow?
In course of the day.
In course of the day, as undertaken by Mr. Das Leonard, government advocate. Peruse the affidavit stub. It appears that although Form B notice has been, Form B within bracket KHL was issued on 14/8. When it was issued?
14/8.
On 14/8/2024. But the encroachers have not yet been evicted. Mr. Das, learned additional government advocate, further said that the matter was last posted. The eviction proceedings were last posted on 10/3/2025. But he submits. But he is not aware of the up-to-date status of the said proceeding. He has not been imparted with up-to-date instruction with regard to status of the eviction proceeding. He however submits that a further affidavit will be filed by the Tahsildar Badasai stating as to what step has been taken pursuant to the Form B notice date 2025 by the next day. Put upon 3 weeks.
2 weeks. Because if they have not proceeded in the meantime, then they will have to
start. Okay. 2 weeks for 29th April 2025.
Obligers.
Item number 3.
May I please bind them?
Filing your application, amending the prayer.
Sorry, my lord, due to the illness of the petitioner, I am unable to file the amended petition.
Sir,
So I may be allowed to one time.
he says that he will be issued upon the opposite party to file the counter. So we are directing him to find the counter and the matter is.
Matter will get
Sorry.
We are allowing your petition there.
We are allowing the prayer. Don't you know last day also?
That's why I may be allowed to
Amend the prayer. Why?
No, definitely I will allow. Due to the illness of the person,
High Court, the order was passed to amend.
Yes.
No.
1 week time may be. That is ill.
Necessarily.
The petitioner is ill.
Yeah, please.
Seriously ill. That's why I am unable to file. 1 week time, ma'am.
Learned counsel for the petitioner prays for further adjournment to comply with order dated 5/4/2025. Stuff. He undertakes to file the
Within a week.
petition for amendment within a week, serving copy thereof on learned counsel for the opposite party. Put up on 29th April 2025.
Item number 4.
Petition for amendment shall be filed in the meantime positive list of learned counsel for the opposite party.
Item number 4.
Item 4, I was supposed to file a counter affidavit. The lordship will grant me 10 days time. I have received one instruction to this morning only that the
Please see order dated.
Yes, ma'am. I am conscious of that.
26/3 and 3/3/2000.
26/3/2000.
Before that, you had received instructions, but that is not complete.
Yes, ma'am. But today morning I received an instruction that it is outcoming has been tried to fill up 10 days. It's a lot.
Mr. Tripathi, learned additional government advocate, last occasion took time that he needs some clarification.
Yes, ma'am. From the order sheet, I am conscious of that.
Order dated 3/3/2025.
6/3, my lord.
3/3. Order number 3 dated 3/3/2025. The bench has already made it clear
3/3.
that only retrospectivity of the
provision.
Yes, that was only set aside. Come out the entire guideline. We made it clear so that it would be easier on your part to file the counter affidavit or take instruction. Still then you are more than 1 month has already elapsed in the meantime.
I agree, my lord. I don't make that. I will come to your lordship. At the last chance, if the lordship provides me, I'll take. Change of hands besides this problem here.
Yes. By what date you can file the counter affidavit or affidavit, whatever you call it. Only a clarification, simple necessary.
The lordship called it on
29th.
Yes.
But 29.
Mr. Das, learned additional government advocate, prays for further adjournment to file affidavit in terms of order dated 26/3/2025. Step 3/3/2025 and 26/3/2025. Step. Hence, the matter stands adjourned on 29th April 2025 if no instruction is received by the or no counter affidavit is filed by that date, the court will proceed with the matter without waiting for filing or without waiting for obtaining without waiting for the instructions to be received by learned government, learned state council or counter affidavit to be filed by the state.
Item number 5.
So this is the case, my lord. Yes.
Horticulture.
Yes, ma'am. Your lordship, horticulture and my lord, my subject is botany. And the advertisement.
The horticulture and the botany is the.
Yes, my lord. My lord, that's
Synonyms or
My lord.
something else.
my lord, as your lordship knows, my lord, that biology, my lord, is this. Then, my lord, from there, zoology, and my lord, botany. Then, my lord, from botany, it comes, my lord, horticulture.
So common ancestor is biology.
My lord, I put a question to myself, my lord. I put a question to
You
myself.
say the genus is the biology and the species are the.
Horticulture.
Well, I put a question to myself, my lord. Subject to your lordships, my lord. Being a student of law, my lord, after completion of my graduation in law, post-graduation in law, my lord, if I do a PhD in economic analysis of law and get my PhD in economics, and the post for which it is advertised is lecturer in law, the question which falls for consideration is, should I be eligible for that? Or in other words, my lord.
No, then there is a rider.
Well,
May I put it?
Yes.
If the eligibility qualification prescribed for such post is the PhD in law,
Well,
whether the PhD in a particular primitive subject, whether that would fulfill the criteria.
rightly, my lord, your lordship have put me that question for which I have given the answer, my lord. So what, my lord, when you take into consideration my PhD topic, my lord, what is required to be seen?
What is the main, I would say, the nuances of the horticulture and the botany?
My lord, I'm just explaining, my lord. Whereas, my lord, botany is a subject which talks about classification, morphology, taxonomy of plant. Horticulture is the practical aspect or practical management of those botanical applications, man.
Whether a botanist can be a horticulturist.
That is what I wanted to show you for lordships. Lordship, I kindly see my additional application. Yes, my lord.
Not have any experience.
Yes, my lord.
The horticulture is concerned. Can he be?
A botanist can be. So I've shown it, my lord. Yes, my lord. So may kindly see my additional application. For a minute, my lord, because your lordship had posed that question to me, my lord. Kindly see my. That's left it to my lord. Kindly see my additional affidavit, which my lord, lordship's direction I have filed, my lord. Annexure 1, page 6, my lord.
Yes.
This is by the same university, Odisha University of Agriculture and Technology, my lord.
No,
So may kindly come to
What?
No.
Mr. Tripathi,
yes,
what do you want to show?
my lord.
Advertisement.
My lord, the additional affidavit because it's
Additional affidavit.
filed by me, my lord, on 11/4/2025.
So,
Black cement.
no, what you want to.
What do you want to?
I wanted to drive home, my lord, that it is the same university wherein I was appointed as a junior scientist horticulture. I worked there from 2006 till 2017,
And when the post of senior scientist for horticulture was advertised, my lord, since I had the expertise in this particular subject, and
Question is not an experience or something. It is the question is the qualification and the degree you must hold in a particular subject. If the prescribed eligibility criteria is the holding of a degree, then in that event you may have an experience. There are many experienced persons who are better than
I'm not
degree
saying,
holder,
I'm
but
not
still
saying
they
I
can't.
had the expertise. On that basis, I was not being appointed because I had done my BSc agriculture. I had done my
I
MSc
do not know
horticulture.
at the junior level, the qualification, eligibility qualification must be different.
Lord, I wrote.
There is no PhD in horticulture.
Oh,
my lord,
just 1 minute.
34 articles I wrote in the international law.
He is igniting the spark to more.
Yes, my lord. He says, Lord, what he says, I have understood, my lord. Any person, my lord, who will go by the nomenclature will say that botany is a subject wherein you got your PhD, whereas the other person, my lord and friends, client, my lord, got in agriculture, in horticulture. But your lordship looks at the topics. That is what is very important, my lord. Both the persons, they did their PhD in a topic called nutrient management. Nutrient management is a subject, my lord, which is relating to horticulture, my lord. Since in the Utkal University, my lord, there is no horticulture department. So therefore, I got my PhD, my lord, in botany. The subject was relating to horticulture. My lord, who decides? Who decides actually whether my qualification is required for that particular subject, my lord? Because as per the university statute, university subject experts, they found me suitable, my lord. Therefore, once they found me suitable, I worked for a longer period of time. Now,
No,
my
we
lord,
do not know what was the eligibility criterion so far as the junior scientist within bracket horticulture is
no,
concerned.
but senior scientists also, the university people, they
There may be, sir. As you know, in the education field, the educational qualification or the eligibility criteria for appointment of a teacher, it is different than the appointment of a headmaster or the headmistress of the college. They require a higher qualifications. Mere teacher will not do. They must possess certain qualifications. So similarly for senior, if they have said that this is the bare minimum qualification, unless you fulfill.
They found me that I have fulfilled. Therefore, they appointed me. After the recruiting agency, their selection committee, which was constituted as per the statute.
Yes.
When I myself was selected, now it was questioned by my lord, the respondent before the Lawrence Single judge. He has now questioned the wisdom, the domain expertise of those subject experts, my lord. And Lawrence Single judge, my lord, without taking into consideration of several lawful plea and the judgments of the Honorable Supreme Court, which clearly says that it is for the recruiting agency, it is for the subject experts, it is for the employer.
No doubt about it. In an academic field, it is the academicians who are the expert in their own field, and the domain experts, if they are there, their decision, because the court cannot impose its own idea on that.
They found me suitable, man.
But the question is when there is a prescribed degree as a minimum qualification, educational qualification for a post, then that degree must be there. Either equivalence, so far as the equivalent or equivalency is concerned, this is the experts who will decide.
They have decided, my lord.
The question is whether if they have wrongly done it.
My lord.
If they have wrongly done it, that does not mean that they are since they are a domain expert, so their decision is.
My lord. I completely bow down, my lord. Judicial review, my lord, is permissible, my lord. Only when it is being shown that it is either actuated by malafide actions, my lord, or if the challenge that the constitution of the committee was not in accordance with the university
qualification, if it does not have. If it does not have the qualification, then in that event also the court can. Suppose a qualification is that he must have the PhD and he has a master degree, the appointment is done. Will you say that the court will be a mute spectator and will not interfere?
Supreme Court, my lord,
Definitely
time and again has said, my lord, in case of public administration and political science, one is having PhD in political science, one is having a PhD in public administration. Supreme Court said, yes, they are related subject. They are related subject. Domain experts who have found that PhD in public administration, PhD in...
So the decision must be there. The
Yes, madam.
university must say that these two degrees are equivalent.
University has filed that. University has filed
Where
the
the university has said that.
Lord, may
these are
kindly see the
equivalent.
university statute, university counter affidavit, my lord.
Where is that?
Lord, may kindly see that.
Show us.
Counter affidavit in the writ petition.
Page 98, my lord, onwards it starts.
Page
98 onwards it starts. May I take your lordships to para 399, page 99.
Where?
Page 99. Writ appeal, my lord.
Who is representing the university here?
Your lordships have not issued notice to the universities.
So till the notice has not been issued.
My lord, this has come in place and this, my lord.
Huh? Where the university says that.
Lordship may kindly come to page 99, my lord.
No, 99 we are. Which
My lord.
paragraph?
Which paragraph?
My lord. Now, lordship may kindly come to one onwards. I'm just reading it out because that's it is submitted that one post of senior scientist
In a relevant subject.
is vacant. ASAP in vegetable crops will advertise along with the other vacant post, the prescribed pay scale and so and so. Annexure 2. The prescribed essential qualification post of senior scientist horticulture is advertised as follows. Now, lordship may kindly come. Significant contribution of research, training, extension, evaluation, as supported by published work, innovation. The opposite part number 3. Dr. Anita Mahanti, as per the career statement, possesses the following qualification. First class BSc in degree in agriculture, first class MSc agriculture in horticulture, PhD in botany from Utkal University. On the committee scrutinized the application, found the opposite party number 3, that is me, my lord, eligible. 6 number of candidates are applied to the post of senior scientist horticulture, including the petitioner. As per the above advertisement, out of 6 number of application, 5 number of eligible candidates, including the petitioner, were called for to appear in the interview, which was held on such and such date. The selection committee comprising the following members, as per section 3(1) of OET statute 1966, and notification conducted the interview of the candidates who were called for the interview on the scheduled date. The vice chancellor was the chairman. 2 co-opted members nominated by VC in consultation with the state government from among the experts in the subject concerning the post for which recruitment is to be made. 2 subject experts. Secretary to the Government Agriculture Department or his nominee, who should not be less than that of the additional secretary rank. An academic nominated by the chancellor. The selection committee, on examining all the aspects of the candidates for the post of senior scientist horticulture, recommended.
Handwritten at page 104, there are many things. 103.
I'm sorry, my lord. I think
it is not by you.
This is to be deprecated, my lord, by your lordships. I myself, my lord, tender apology, my lord.
No, what is this?
It should not be there.
It should not have been annexed, my lord. It should not have been annexed.
Mr. Padhi, how could you?
Inadvertently, I beg apology.
These documents should not be
I
filed.
beg apology. Inadvertently, it has been. It will not be repeated, my lord. My lord, I understand, my lord.
But Mr. Counsel, the difficulty is I have gone through this affidavit.
My lord.
Nowhere the university has said that this is what is the rent and this is what is equivalent to this.
My lord.
Simply says that the screening committee have evaluated, the recruitment committee have taken everything on merit and then selected you.
No, Lord, may kindly come to page 118. Another affidavit which was filed.
What affidavit?
Lawrence Singhal has, my lord, direction. Lord, 1181. This is an additional affidavit by the university. Page 118. It starts from my lord. 116, man.
Yes.
It is here that though opposite party has, that is my lord opinion for your lordship, my lord.
118.
Yes, madam. Second paragraph, my lord. There are two paragraphs.
Again, the same markings are there.
I understand, my lord. This difficulty is.
Admission by university. What is the admission by university?
My lord, I'm sorry, my lord. This, my lord, I completely bow down, my lord. I your lordship, my lord. Anguish on the subject, my lord. I understand, my lord. It is mentioned here that the opposite party number 3
This is here, first thing.
has registered the PhD under broader subject botany. But a PhD thesis is integrated nutrient management in applicant marigold. CV circular for higher yield and quality flowers. Our guides were Dr. P.K. Mohapatra, Professor, Department of Botany, Revenue University, Cuttack, and Dr. C.R. Mahanti, Professor, Head of the Department of Floriculture and Landscaping, College University. The members of the selection committee were the subject experts who certified and recommended her selection after evaluating her PhD thesis. So that expertise in treating PhD thesis may not be questioned.
That does not answer the query made by Honorable the Chief Justice.
My lord, the subject experts. They, my lord, therefore, my lord, I brought that analogy. Tomorrow morning, if I do after my LLM, the same thing will come, my lord.
You become emboldened by one sentence in the said affidavit. Horticulture is a part of a parent subject botany. Now,
That is the only.
My lord, may kindly see the PhD thesis of both the person, nutrient management. Both the persons have done that, my lord, on the same subject fellow. Both of them have done.
Yes. He accepted.
Deeply grateful.
Issue notice.
It's because of this affidavit.
Yes.
Deeply grateful.
Requisites for issuance of notice on opposite parties, on respondents, I'm sorry, on respondents by registered post stroke speed post with AD shall be filed by 17th April 2025. Put up this matter on 16th May 2025, along with tracking report of the Postal Department. Is there any application?
Appointments have
Yes.
Yes, stay operation of the judgment.
For the respondent,
Stay operation of the judgment.
petitioner in the reach petition.
Oh,
I will take notice for respondent number 1. I am on caveat.
Oh, sorry.
And my lord, it might not
Okay.
passing an interim order.
Okay. Yes, just a minute. Since the respondent number 1 has entered appearance through caveat, no notice can be issued. A copy of the appeal memo shall be served on Mr.
Sanjay Rath.
Mr. Sanjay Rath, Learned Counsel for the respondent number 1 by tomorrow.
They have already served.
They have already served. Okay. Strike down. Strike it out. The requisites for issuance of notice to opposite partner, respondent number 2 to 4. Start. Then IA. Yes, what do you say?
My lord, on the IA, my lord, since I am on caveat, my
Yes.
my lord.
Yes.
My lord, my humble submission is that, my lord, the advertisement in clear terms stipulated PhD in horticulture.
Mr. Rath,
My lord,
since you have admitted it for hearing,
my
we have to protect her.
My lord,
He has
my
already been
humble
selected.
prayer, a short date may be fixed, my lord. My lord, no interim order may be passed. A short date may be fixed, my lord.
Her appointment is at stake.
Her appointment in view of the order of Honorable Single Judge.
Have you seen the affidavit of the university?
The affidavit, my lord.
So
My lord, I
in
can
that
clarify.
event,
If my lord
that is
will
what
permit
is the main issue. Now, University has said that this PhD is done by both of them in a particular primitive subject. Both of you. Then in that event, one university grants as an horticulture, one as a botany. That is what they say. Who is the best person to decide it?
Milord, if there were two persons, both having a PhD in horticulture, then Milord,
No, in the same
experts.
subject. The question is the same subject, nutrients.
Nutrient management.
This is what is the same subject.
that
Now,
affidavit.
one awarded or say the nomenclature of the degree is given a PhD in botany, and one university, the nomenclature is given as a PhD in horticulture. But the subject
Subject
study is one and the same.
Milord, my subject
sir.
is different. My lord,
No,
we see.
sir.
My lord, we see the
No, sir.
certificate. The subject is absolutely different.
If the
My lord, I'll
expert,
show
if
I'll
the
show the
expert,
certificate. I'll show
if the expert has come, we're giving you a short date, but that is what we find.
My lord, allow me to place the certificates of both persons. My lord, that is subject.
Are we an expert, sir? That is what we are saying. The law is very clear. The Supreme Court, if you want, I can give you an innumerable judgments on this. It says that so far as the academic part is concerned, the interference of the court minimum.
Yes, my lord.
It is the
I absolutely
academicians let them take care
before
of
the
that.
honorable single
So
judge,
let us see.
I had placed my lord
It's not
6
that.
judgments of the honorable apex court.
Whatever.
Mr. Rathod,
Yes.
you are not passing an absolute interim order.
I bow down.
As my lord said, you
I
may
bow.
file your objection.
So on that, my lord, on that point, I only pray my lord a short date may
And
be given.
the university has to be heard.
Yes, my lord.
Exactly. University has to be heard.
So notice has to be given to the university.
Issue notice as the above. Accept onset of process fee. Heard Mr. Tripathi London Senior Advocate appearing for the petitioner along with Mr. Padhi London Counsel for the appellant. And Mr. Rath Learned Counsel appearing for respondent number 1 on caveat. Start. Since we have issued notice in the appeal, sorry, Mr. Rath Learned Counsel for respondent number 1 pressed for a short adjournment to file an objection to the IA, Azure IA. Start. Since we have the appeal for hearing, comma, issue notice. Yes. Heard learned counsel for the parties. In the additional affidavit, why?
Second additional.
Second.
Where is the second additional?
It's 118, my lord.
Page?
118.
118.
Yes, ma'am. Second paragraph.
118. Yes. Product subject for 40 part of subject. In the at para sapara 5 of the additional affidavit filed by the Orissa University of Agriculture and Technology, it has been stated that though opposite party number 3 within bracket appellant hearing has registered PhD under broader subject botany, comma, but her PhD thesis is integrated nutrient management in African marigold within bracket so and so chemical name so and so. Here for higher yield and quality of flower. Please quote the entire thing. It is there in page 118. Further, it is stated in the said paragraph that horticulture is a part of parent subject botany Step. Taking into consideration the affidavit filed by the appointing authority, namely the Orissa, namely the university, we think it proper to protect the to pass an interim order. Pass an interim order protecting the continuance of the petition of the appellant in the post of senior scientist horticulture. Accordingly, it is thus as an interim measure, it is directed that the impugned order dated 11/3/2025 passed by learned single judge in WPC number 11144 of 2018 shall not be given effect to till next date.
The appellant shall not be entitled to claim any equity on the basis of an interim order.
Since I'm on carry, I'll take chance. I know Milord, but can I Milord show only
Conserve the energy, exhaust on the returnable date. Don't worry. Come, we'll hear you.
Please,
we'll hear you.
As my love.
Item number 6.
That too.
Item 6, I'm once again apologize, my lord, last chance is given, but I am not getting instruction. My mistake of our office also that they have sent to the railway to this different region and the DGM law. So another 7 days time.
My brother has already recorded that they are not responding.
Thus here in the examine the record,
multiple times the adjournment has been shortened.
Paragraph 4 of the last order.
Yes. That's why initially I said that I will apply because we have not received any instruction or given 7 days time. But this I have examined this last order, last annexer 14, last page.
If you want to submit on merit, then
my lord, I am taking 7 days time because letter has gone to this.
It is up to you. You have. What if
we have to impose cost? Because it is it has been made clear a judicial order.
Yes,
has been made.
I bowed down to because
the
last chance has been given. I am present in the court and also may I pray, my lord, because I am praying a short adjournment for 7 days.
Yes, subject to payment of cost. In spite of the order dated, while adjourning the matter on the prayer of Mr. Padil or at DSGI on 26/3/2025, this court has made it clear that if is not obtained, instruction is not obtained by the adjourned date, the court would proceed with the matter on the materials available on record. Mr. Padil under DSGI prays for further adjournment to take instruction in the matter. In view of the above, this court is constrained to impose cost for granting the prayer made by Mr. Padil and DSGI. Accordingly, it is directed that the matter stands adjourned to be listed on 22nd April 2025, subject to payment of cost of rupees 5,000 to learned counsel for the petition by the next date. to payment of cost of rupees 5,000 to the welfare of the High Court Bar Association by the next day.
I was initially happy with the order.
Okay.
Much. This blacklisting of the candidate, this is serious consequences.
Serious consequences. You have not issued.
I have gone through this slip. Then it's in that this High Court of Guwahati has passed something which has submitted this court in different way. That will I will analyze in the next day. That's why
But the difficulty is because the blacklisting has I think the very.
It has been caused a stigma.
It has been caused.
not that is it.
That is
Not been caused according to this record. So unless they are not getting
The order says it has been caused.
we are going to adapt to the matter. That's not advance can happen.
Let us see. Let us see. You should have come up.
Watch it.
Item of 62, college actually taken out one second last when I was cleared with Justice Number 7 and matter was adjourned because Adjournment was not present. And today my lord has fixed to
See, sir,
but for today it's not possible.
appears to be, but
well, I'm not like right to leave. So may I say, let me take note tomorrow. I have cleared.
it will, don't worry. Whatever is not taken up, it will spill over for tomorrow. Don't worry.
My prayer is don't take note tomorrow to 2 o'clock. Hundreds of dancers artists have been rendered jobless and waiting, facing near starvation. Others waiting eagerly for.
Give us some time. We'll do it. Today, some matter consumed a lot of time. What can be done?
So,
We'll try. Don't worry, sir. Tomorrow it will be there. Don't worry. Yes. Yes, let us see. No difficulty.
Item number 7.
Yes.
An instruction is sought for my.
The allegation regarding creation of revenue inspector circles.
There also another matter is there.
There are more than one.
I
know. You have seen.
My lord, the allegation is
Here, my deal annexure 3. Procedural as recommending Pulsar as a.
Sir, I was just trying to understand, sir, this RI circle, whether to open a RI circle or not open a RI circle, it is the government who has to take a decision. Is there any law that they are bound to create a revenue inspection circle?
My governing law. Deal annexure 3. Procedural was recommending Pulsar as a.
So what is I please pardon my impertinence in this regard. What is the main charm, may I use the word, main charm in having a RI circle? What is the advantages and disadvantages one has? What for? They are is within the part of the state. Anything is within the part of the state. State is the guardian, custodian. They have to do it.
Yes, ma'am.
Take care of that.
But by annexure 3.
No, Tehsildar may have done it. Everybody approaches, Tehsildar does it. But whether that decision of the Tehsildar is binding is a legally enforceable right.
If the local MLA interfered, thereafter the annexure 4 was issued, madam.
We are not concerned with the influence, but we are concerned whether there is any mandate or is a legally enforceable right. What's your instruction, sir?
It is not a legally eligible right.
Then how the PIL lies?
Mr. Mishra,
My lord,
please satisfy the court how this recommendation or suggestion, whatever you call it, or the recommendation of the Tahsildar is legally enforceable.
Tahsildar was recommending our area, my lord, also that.
Sir, that is factual aspect, sir. There is no problem. Your name, your circle has been recommended.
Yes.
But how it can be enforced in a court of law?
But what made the area? I
No, why not? If they want to change the opinion, then can they not?
Between two areas, also than that area, our area is far better, madam.
So why? So it is up to the government who has to think about it.
Yes.
Why?
But they have not thought, madam. Only influence of the
that
local
is
MLA.
up to them. Then
That
can we impose something on them? Is what your instruction? Are you going to take into consideration?
Because they belong to that Palsada village. But however, subsequent, first the name of the village of Palsada was recommended for consideration.
Correct, we have seen that.
Then subsequently the name of the village has been changed. Now the Tahsildar, your lordship may kindly have a glance that they have constituted a committee and they have put under notice the present petitioner of Palsada village. So also the Damjar village.
Objection has been called for.
Now, all of them have been asked to appear before the committee and raise their grievances so that it can be taken note of.
This is fixed on 25th of March. So take a decision.
Yes.
Take a decision. We are not keeping this matter open. We are disposing of on that.
Let a copy be. Yes, this has been done now. For last, yes. That's only student 12 for.
Petitioner in this writ petition prays for a direction. Sorry, grievance of the please strike out. Grievance of the petitioner in this writ application is with regard to non-consideration of the recommendation of the Tahsildar, which place
Boden, madam. Boden under district MOHAPATRA.
Tahsildar Boden, opposite party number 2 in the district of MOHAPATRA, for white letter number
next at 4, madam.
White
1/11/22.
By letter number 1923 dated 1/11/2022 Annex 4 to open a new RI circle at village
Damjar, madam. Serial number 7.
Damjar. Step. It is Mr. Mishra and the petitioner further prays for a direction to the Damjar in the under Putsada Gram Panchayat. Step. Petitioner prays for a petitioner further prays for a direction to the opposite parties for opening of a new RI circle at village Damjar under Potsoda Gram Panchayat stuff. This writ application is filed in the nature of public interest litigation by the petitioner, who is a villager of
Polsoda.
Polsoda. Stuff.
Under three, serial number 7.
The Tahsildar Polsoda, Tahsildar Bodin, opposite part number 2, while his letter number 1923, while his letter under Annexure 4, has recommended to open a new RI circle at Damjar stuff. Subsequently, that it is the subsequent notification. What is the earlier?
Annexure 3 is the
Annexure 3.
Yes.
But letter number 3095 dated 26/11/2021 under Annexure 3 to open a new RI circle at village Polsoda stuff. But subsequently, by letter number 1923 dated 1/11/2022 Annexure 4, he changed his mind, issued another and recommended to open a new RI circle at village Polsoda, at village Damjar stuff. Although the petitioner and other co-villagers made representation to the collector Mohapada for redressal of their grievances on 5/10/2024 Annexure 5, but the same has not yet been redressed. Hence, finding no other alternative, they have filed this. The petitioner has filed this writ petition in the nature of public interest litigation. Mr. Das, learned additional government advocate, on instruction, on receipt of instruction, referring to the written instruction dated 12/4/2025, submits that the Tahsildar Bodel has fixed the date of hearing for opening of new RI circle at village Damjar on 25/4/2025. If the petitioner has any grievance, he may appear before the Tahsildar Bodel and put forth his case for consideration. He further submits that the public interest litigation in the present form is not mental. Considering the submission made by learned counsel for the parties, this court is of the considered opinion that since the Tahsildar Bodel, opposite party number 2, has fixed the date of hearing for hearing objections of the person interested on 25/4/2025 with regard to opening of new RIs at Damjar, the petitioner may appear and put forth his grievance before him. With the aforesaid observation, the writ petition is accordingly disposed. Writ petition PIL is disposed of.
Subject to my lord's kind permission, my lord. My lord have indicated in the order that action is being taken to open the RI circle in Damjar.
That is not there.
But the notice is with respect to the villagers of Damjar and Palsara have been asked to appear so that a decision can be taken whether it will be
written instruction referring to the written instruction submits that notices have been issued to the villagers of village Polsoda and Damjar under Damjar to appear on 25/4/2025 and place their and participate in the hearing for opening of new RI circle at village Damshan. Sir.
For opening of RI circle.
Opening of RI circle. For opening of RI circle.
What is the importance of this opening RI circle? What is this? For what purposes?
That is the reorganizational aspects, my lord. Territorial jurisdictions is only to find out the accessibility, proximity and accessibility of the villagers from the RI circle headquarters to be taken into account.
What is the purpose of RI? What they really do?
Revenue inspector, my lord.
Inspection. That is what is this? What is the purpose of creating an RI circle?
Annexure one that
What?
that it is there. Proposal. Since revenue inspector is the cutting edge, my lord got it. Annexure 1, page 15. Second part.
They are basically the field functionaries.
So nothing, I think it makes no sense.
It's purely a policy decision of
It makes no sense. Anybody, any nearby and there is no problem. Why you want it at the doorstep? It appears that you really wanted it at the doorstep. And this comprises of many villages. Maybe sometimes 6 villages, 7 villages, 8 villages. They are comprised of.
Is there any geographical barrier?
No.
It's the maintenance of the record of rights and all, everything is there.
In fact, these are all statutory functions. These are all statutory functions.
So it makes
regarding mutation, miscellaneous certificate, these are all various statutory functions.
It hardly makes any difference if it is at Bolsada or.
It is like I just wanted to, RI circle means it is like a block.
No. It is a revenue inspector under the Tahsildar.
No, I have come from a state where the block land and land reforms officer is there, who takes care of that. Then district land and land reforms officer is also there.
Yes,
so he takes care of that.
No, it is under in a block there is a Tahsil. And under the Tahsil there are separate RI circles. Those who will collect the cess and they will facilitate the person for register for.
It is only the facilities at the doorstep. This is nothing more than that.
No.
This is what is the policy decision. How can a PIL lie?
Exactly.
Item number 8.
Each time may be granted, I will file the counter affidavit. I have received the instructions, my lord. Here the tender call notice is under challenge because the technical bid was rejected of the petitioner. He was a successful bidder. His technical bid was rejected.
And thereafter the entire tender was also scrapped.
The entire tender was once scrapped.
The single bidder.
Because if I will be substituted, there will be 2 bidders, my lord. They have rejected, though I have submitted all documents they have stated. There is no.
Now the entire tender is rejected. Now they wanted to float a fresh tender. You participate.
No, matter because I am successful. I will be successful when I think that I have quoted the lowest price because the ground they have rejected your lordship may see the ground they have rejected. Somebody has made an allegation
that I have seen. Tapash Kumar or something.
Yes, man. Who is a tender who did not submit any document against me?
That is wrong. Where is that document? I read it somewhere.
Where is that? And annexure, page 36.
Annexure?
Annexure, that is annexure 5. My case is 4, paragraph 4.
You are
Raghunath Naik. They have stated that he has submitted all the required documents of the tender.
The objector says, give me some time.
But there is a specific bar.
No. Please look at it. Look, please come to page 36, paragraph 4, middle, just below the middle. He also claimed, he's just above, he is not working as a president of ATF. He also claimed that if any allegation of such and such is found to be true, then he is ready to get punishment as per law. So he was bold enough to say, the objector has verbally requested to provide some evidence supporting his allegations. So he does not have any document with him. However, moreover, there is ambiguity in the statement of his statement. What ambiguity, I do not know. Under the above circumstances, not to select. And on a technical bit, you have.
That is what I have asked them, whether they have conducted any inquiry, whether they have come to their own satisfaction that the.
This is what a satisfaction is. Sir, I understand that this committee could have postponed the decision, that let that objector come with the convincing material or cogent evidence. He says that I am not working as a president.
But they have stated without any inquiry.
And then he says that if any document comes, I am ready to accept it. So mere a bald allegation, and then the technical bit is rejected. A valuable right of participation is lost, it's taken away, sir. Can't be. And this tender is of which year?
This year.
This year.
How can it be done, sir? And what instruction, what counter you will file? Just show us. Can you support this ground? A person came and says that he has committed a crime. That gentleman says, use a document that I have committed crime, I am ready to accept whatever the punishment will come. That gentleman says, I have some evidence I will produce, give me some time. Authority, without doing it, says, now punish him on a bond allegation. Without looking at it, whether any crime was committed, any offenses there, nothing, punished.
That is why I have specifically asked them. I have gone through the record. I have specifically asked them to whether they have conducted or they have straight away come to a conclusion that they have only proceeded on the only other.
Have you read the Charles Dickens Alice in Wonderland? He says that behead him first, then the trial will begin. You have done the same. You have done the same thing. Behead him first, and then the trial will begin. Sir, there was no material before the authority. That he has committed. Even an objector does not have any.
Does not have the documents. He prayed for time. The objector prayed for time to produce the documents.
The tender condition was he should
What
not be a rice miller.
True.
That is
He
the
says
tender
I am
condition.
not. He has blatantly denied that I am not.
No, man, that is also not the allegation. The allegation is I am doing the PDS work. That is not correct also. The allegation,
you have said that.
Transporting PDS.
Yes, my lord. I am not doing transporting PDS. And I am not a member of Atma also.
Forget about much less about
And they have stated
precedent.
that they select the bidder without any inquiry. They have they themselves stated we don't want to make any inquiry. Committee decided not to select the bidder without any inquiry, my lord. Last line.
But we have to wash it.
Also, may grant me one chance. A week's
How many
chance.
chances?
A week's chance. Why not
Given you
already?
given you on the last open also. I think at least give you an opportunity.
I have gone through the documents that I duty to.
You are a responsible officer, you know.
I understand. It is apparent. I have also put them that question that you produce whether you have inquired or not.
But can we not, there is nothing, neither you have made an inquiry, nor you allowed the objector even to produce documents. On what basis you cancelled? Only saying that, vaguely saying that the ambiguity in the submission of the petitioner, the bidder.
May I pray one thing, subject to my lord's consideration? My lord may pass an order that let them produce the document basing on which they have proceeded.
He is not before us.
He is not before us.
No,
This tapas or what?
The authorities, those who have cancelled, whether they have conducted an inquiry on the basis of the allegation made by that tapan, and they have proceeded to cancel the bid of the petitioner. So to that extent, let them.
Sir, can you supplement?
Without any inquiry,
Sir, can you supplement to the, if you, let us, Mr. Das, let us accept that.
Cannot improve on the records.
Exactly.
That I fairly concede, my lord.
We are trying to impress upon you. Can you go beyond the record?
No.
And this is all more so because of the MS Gill judgment of the Supreme Court.
Yes.
You can't.
Cannot be approved by way of a counter affidavit or affidavit.
Nothing.
That is the I cannot.
And the irony of the thing is, the gentleman who has raised objection, his technical bid was also rejected. Just imagine. Serial number 7. Only serial number 1 was found to be established. What authorities are doing? We are watching so far as this this order of cancellation of the bid is concerned. We are though it is within your domain, but on this ground we are not supporting.
You may pass it with only.
And then
I request a formal objection recorded.
We will say that so far as this tender process is concerned, the committee is already there. Let them apply, and if there is any document, then the committee will review its own decision. What?
Yes, you are.
Have you floated the new tenders? Just
No, they have
a fresh
floated.
tender. Just tell us.
But they have floated, it is no bidder can manage.
So again, the last.
Therefore, this Honorable Court has stayed the further tender.
Fresh tender, no
Bidder has come. I have the instruction also. Because they are there, make a new guideline that there should be a EPF certificate. But this is a transport contractor. There is no need of EPF. For the first time they have introduced it. For that reason, no bidder has come.
What is this EPF?
Employee Provident Fund. Because the person having 2 trucks will participate in the tender and hire more.
That I have seen. You have said that you own 2 or 3 trucks and
Yes,
3 leases.
So or he can take on lease, my lord. But why he will apply for the EPF if 20 members are not there?
I'm just, if your lordship allows me, I'll just take instruction on this fresh tender to what extent they have proceeded on the basis of this fresh tender.
No, there is already a which says fresh tender is not to be issued in the next date of week.
Yes, so it has not been finalized.
Should not
You
have
are the
any- not-
lordship.
the financial bid, sorry, the technical bid. No, sorry. The tender was floated. for appointment of a transporting agent under PM Ocean within bracket MDM program for Nayagar district for the period from 1st October 2024 to 30th September 2025. Admitted the petitioner participated in the said tender. Answer. Yes. The tender is to be submitted in two parts. First, technical bit. Secondly, the financial bit. The petitioner participated in the said tender, offering is the price, and have also submitted all the requisite documents in order to satisfy the conscience of the tendering committee that expertise in transporting the goods. The technical bit was before the technical bit could be opened, an objection was raised by one of the bidder that where is that? Annexure?
Annexure 5, page 36, that is written, man. Page 36.
Bidder that raising one of the bidder raised an objection. Before the opening of one of the bidder that the petitioner has been transporting PDS and MDM rice for last 15 years and also working as a president of ATMA committee of Agricultural Department. It was further alleged that the petitioner had been transporting MDM rice without any tender by the DEO Nayagar and have also submitted the experience certificate obtained by manipulation for participating in the tender. The district tender committee meeting was held on 29/10/2024 at 3:30 p.m. to open the technical bid, and the decision was taken to cancel the technical bid submitted by the petitioner, as the explanation furnished by the petitioner is ambiguous. At the time of motivation, the respondent authorities were restrained from floating any fresh tender for the same work, which is still operating.
But they have cancelled it.
Operating.
The new tender they have cancelled. The new tender, which has been stayed by the Honorable Court, they have cancelled it.
In course of the hearing, it appears, in course of the hearing, we are informed that the tender process initiated earlier, in which the petitioner offered his price, was cancelled by the district tender committee meeting, was district by the committee in a meeting held on 29/10/2024, as there was only one successful bidder. Though the order, though the injunction was passed not to publish a fresh tender, but it is informed to us that in the interregnum, the fresh tender was floated, which was subsequently cancelled.
The fresh tender is part of Annex 6.
Subsequently cancelled.
It has been subsequently cancelled.
Be that as it may, we are not concerned with such decision. The only point involved in the instant writ petition is whether the district tender committee have rightly rejected the technical bit of the petitioner, and the ground assigned thereto can withstand on the test of reasonability. We are conscious of the proposition of law that the writ court should seldom interfere with the decision of the authority whether to continue with the tender or to cancel it. But equally, if the cancellation is preceded by any decision creating an impunity, such decision must appear to be reasonable, and there is no fetter on the part of the court to interfere in such. Next one. The present case is a classical example of the second concept, where the district tender committee, upon analyzing the objection raised against the petitioner, rejected the technical bit solely on the ground of ambiguity in offering the explanation. Interestingly, the objector who made a bold allegation was invited to produce the cogent evidence in support thereof by the said committee. But instead of producing any document, he sought for an accommodation. Yet the committee proceeded to reject the technical bill on the ground of ambiguity in the statement of the petitioner. It was a specific stand of the petitioner that he is not working as a president of the Atma Committee of the Agricultural Department, nor transported PDS rice in the previous year. He categorically admits that he had been transporting MDM rice as per the order of the collector, Nayagar, and DU, Nayagar. According to the petitioner, the same cannot disentitle him to participate in the tender, nor the conditions of the tender creates any brindle in this regard. More particularly, to a transporter who have been transporting MDM rice as per the order of the collector, Nayagar and DO Nayagar. Even an administrative authority cannot shirk its responsibility in providing a plausible reasons in taking a decision of rejection of the technical bid in a tender process. Right to participate in tender is a valuable right. Which cannot be curbed, CORBD, which cannot be curbed. Taking a circuitous route not permitted in an administrative field. The moment the serious allegation is made against the petitioner, that he is a working president of Atma Committee and transporting PDS and MDM rice since last 15 years. Such allegation is to be substantiated by a cogent evidence. And the committee should not have proceeded to reject the bid on the ipse dixit of such allegation. Ironically, the committee proceeded despite the objector having sought time to produce evidence in support of such allegation, which does not appear to us can be withstand on the reasonability test. The decision should be reasonable and rational and should not percolate the sense of the any bias or a malice. Stop. Since no fresh tender has been floated as of now, nor any contractor, a transporter has been selected / appointed. We therefore find that the decision taken by the committee warrants interference and it would not cause any prejudice any person having accrued right subsequently. The order, the resolution. The resolution.
Minutes of
Minutes of the district tender committee meeting.
The resolution of the district tender committee. Now, decision of the district the tender committee in rejecting the technical bid of the petitioner is hereby caused and set aside. Since the entire tender process was cancelled solely on the ground of a sole bidder, and in the event the petitioner is found suitable in absence of any evidence to be produced by the bidder, there is no fetter on the part of the authority to proceed with the said tender, and therefore the ultimate decision of cancellation of the tender process is also caused and set aside. The district tender committee is directed to decide to take a decision on the technical bid submitted by the petitioner afresh after giving an opportunity of hearing both to the petitioner as well as the objector, and shall take a informed decision on the basis of the so produced. And first off, these decisions shall be communicated to the petitioner. Since the other bidders whose technical bids were rejected did not approach the court, this judgment would be restricted to the petitioner only and shall not be treated as a precedent.
As per the condition, where your lordship is stated that as per the evidences and tender condition.
What tender?
Tender condition.
Then they know the tender condition. What more?
Oblige. Item number 9. Nine.
You're not to directed to after instruction. It should be instruction. It's a bit voluminous. The lordship will look at para 6 and 7 of the instruction. That would suffice, my lord. Para 6 and 7.
Roman 6 or what?
No, my lord. It is numerical 6 of that instruction. Page 6, para 6. The argument made by the opposite party in the writ petition that due to storing of excess water in the dam, the wild animal and tigers are coming towards the villages and damaging the farmland and attacking the village people. It is humbly submitted that as the dam authority has alienated 575 hectares of land and paid 35.14 lakhs in favor of the forest department for compensatory afforestation of non-forest land instead of submerged area, and the compensatory afforestation over an area of 548 hectares has already been raised by the Orissa Forest Development Corporation, that is OFDC Limited, during 91, 92 and 92, 93, and had taken possession of the territorial division career. Hence the fact is not true. Then the next para is important, my lord, that the argument made by the opposite party in the writ petition, that is petitioner, they have written it by mistake, opposite party. The writ petition that the irrigation officers are storing excess water beyond the approved permissible, that is RL 350.60 level
it is humbly submitted that during rainy season, peak inflow occurs from June to December as the catchment area of the Upper irrigation project is surrounded by hills. So the water level in the dam drastically increases during this period as the water from the hills comes to the catchment area. As the discharge capacity of the spillway is 3,555 cubic, hence the dam in charge felt hardly necessary to store water above the RL 350.60 m during the rainy season to save the human beings and domestic animals in the downstream of the dam. If the dam in charge discharge excess water into the river, the nearby habitant in the downstream of the dam will be highly affected by the flood water and nearness of the different villages like Sukli, Dharmabandha, Dujabhatta, Powertola will be damaged. The domestic animals are also faced problems due to discharge of excess water flowing in the river from the spillway. Further, there is a low-level bridge near the village Sarangpong, which is connecting.
It is only during the rainy season, otherwise
Yes.
you maintain it.
Yes.
But the difficulty is whether the dam has a capacity to hold such an excessive water.
Yes, madam. Yes, madam.
Now you are concerned with the several villagers, the inhabitants, that if the excess water is discharged from the dam, many villages they will face the flood.
Yes,
there are a low bridge.
Yes.
Which can also washed away because of the flow of water, disrupting the communication.
Yes.
But the thing is that if the dam bursts or it breaks, I think the casualty would be more devastating than.
Mr. Das, what is whether you have received instruction with regard to management of water level? There is a blue book of Hirakud Dam project. You know it very well.
Yes.
So before rainy season, they maintain that level of water, expecting that much water will flow in to the catchment area.
Yes.
So like all the dams, there is a water management system. They maintain a blue book for all dams. What is your instruction with regard to that? You are as you say, it is a usual feature in rainy season. Unexpected flow of water to the catchment area is there. So to meet with that situation, the water management system should be there. Is there any water management system of the Jong that dam? What is your instruction with regard to that? You must be. It is not a feature of 1 year or 2 years.
Permanent.
It is a recurring one.
Recurring one, and it is a permanent process.
Permanent process. Yes. So there must be. What is your instruction with regard to that?
We'll take care of the badgers and all these. They are coming there. We will take care of that. Don't worry. But what about this level?
But that probably has been answered in para 3, madam. Para 3.
Not answered.
Yes, madam. Because the height of the dam has been increased from 350.60 meter to 354.10 meters. So, as per ordinance, in the height of the dam has been increased.
And then it increases to 350, means only small portion is left.
Yes,
just imagine. And normal, as my brother says, that there must be a blue book or something is there, or
that
this one, where I think it should not exceed more than 3/4 capacity. Should not.
Exactly. If you raise the water level in the dam, backwater will the many more area will be submerged. That is obvious.
But
to meet with that, every dam project has a blueprint.
It is continuous discharge of the water so that at least the level is maintained.
Exactly.
Because of the increase in the level, the forest land was affected. That is the allegation.
It's all right.
Basing on that, my lord, they have already proceeded for afforestation. Adequate land was given to the forest department, and they were also compensatory done. To that effect, the care has been taken.
What about the animals who are there in the forest?
But their allegation is animals are coming to drink water. That is why the villages are affected. That is what is the allegation.
They come out of their core area
because
to the village. The wild animals come out of their core area to the village so that casualties are.
Because it is the dam situated at your sanctuary lordship.
Yes, Khariar, near Khariar there is a sanctuary.
No, so it is requires the permission of a National Wildlife Board
That is
to maintain access.
Your
Regarding
your instruction does not appear to be mindfully given.
We are conscious that the necessity of creating a dam is there. There is no doubt. So how to do it? I mean, everything should work in tandem. How you will do it?
That is
You said 354, and then you say that during rainy season 350. Just imagine.
What would be the situation? 4 feet only. Only 4 feet left. And there is also that there might be casualty to the dam itself. Longevity of the dam or sustainability of
the ensure that how much it can hold the water.
In your lordship, may I please, in Annexure 2, the irrigation department also committed that they should not be exceeded above the 350. Annexure 2, kindly glance to the Annexure 2, your lordship.
So your instruction appears to be not complete.
What instruction?
My lord felt saying that the height of the dam is 357 meters. That is what he is saying.
But
yes,
7 feet hardly makes any difference. 4 and between 4 and 7, hardly 3
feet.
It was illegally increased by some irrigation officer. That it is mentioned in the order of the Honorable Supreme Court, your lordship. It is also illegal. You can't increase.
You cannot also increase it by of your own.
I'll take further instruction from you.
So will you take back your instruction or will keep it in on the record?
Keep these instructions on record. I'll get press instruction.
Written instruction. Written instruction imparted by the
superintending engineer Mohapatra
by the superintending engineer Mohapatra Irrigation Division Mohapatra is taken on record. Mr. Das, learned additional government advocate, pressed for further adjournment to take specific instruction in the matter. Hence, the matter stands adjourned to be listed on. When can you obtain? Mohapatra.
Keep it to 24.
24th April 2025. Instruction, further instruction shall be obtained in the meantime for
Item number 10.
May I please, your lordship? The District Education Office Keonjhar invited tender from the manpower service providers, my lord. And the petitioner is a manpower service provider along with others, my lord. He applied for the tender and on 26/12/2024, technical bid was opened. Thereafter, financial bid, my lord. I, along with all of other two service providers, equally quoted price bid. Thereafter, lottery was conducted and I became successful. That is the instruction, my lord, under flag B.
You're lucky, not successful. Say I was lucky.
My lord, I was lucky, grateful, my lord.
The lottery.
My lord, grateful. With the same price bid, I became the luckiest contender, my lord. That is
Why they do not adopt that everybody should come and bid amongst themselves.
Reverse bidding. If the price bid offered by them is equal, then that should be a bargain.
My lord.
But competition amongst them.
Yes. The instruction regarding that lottery, my lord, it was called a flag B, perhaps, my lord, of your lordship's. The last occasion, my respected state council has hid that before your lordships.
One number of bidders have qualified for technical bid and opened. We quoted the same price.
Lottery was conducted. But since there is an allegation that you are blacklisted, that is why it was not declared.
Petitioner has been blacklisted.
That is the allegation.
Earlier, my lord, earlier in a case in 2015-16, for 3 years, that was the allegation. But that is already over, my lord.
Why the price of two tenders were they were lower than the tender?
Yes, ma'am.
They quoted a price below them, but they were discarded.
They are discarded.
Why?
Below them, it's not that, not less than the minimum.
What is this minimum? You wanted a L1, lowest price. They quoted the price lower than him. Has it been H1, H2? I can understand.
Yes.
It's a L1 and L1. So lowest one and lowest two.
Regarding Mr. Nanda, it is regarding supply of manpower.
Manpower, yes. In yes, my lord. In the district of Kim.
You are a Royal Security Agency.
My lord. My lord.
We see blacklisting agency in the district education department,
Bolangir, but that is for 3 years, my lord. And that is already gone. That period is already gone. Now I have been working in many districts, my lord, providing services. But the person who has become unsuccessful, he made a complaint to that effect. Last occasion also, my lord, this matter was raised before your lordships. The instruction.
Anyhow, the office issued the letter to additional secretary. Mass Education Department approves. What is the instruction?
That on 21st of March 2025, EU Keunjhar wrote to the additional court advocate disclosing therein that from the government they sought some instructions. It has not.
The entire thing was initiated, I think, after this court directed you to take instruction. You are sitting idle. Why your obligation, your duty should be reminded of by the court. He was blacklisted for which period? It is not clear from your instruction.
It is not clear. In the year 2016 only he was blacklisted. That is available here.
3 years, PWD code.
Yes.
3 years
It should be over.
If then why tender floated in the year 2024? He should be debarred. If he has come out, he has come out successful in the lottery system.
It's not clear.
It will given to somebody else.
No, my lord. No, my lord.
He has not been declared successful.
Whatever.
No, was lucky enough to win the lottery.
Yes.
So, but thereafter the allegation was that he has been blacklisted.
That is why it has not been cleared.
So the difficulty is that then we'll have to give him.
Yes, ma'am.
If you produce the document that it was for 3 years.
My lord, even that instruction was not served on me. That thing was. It is only for 3 years, my lord.
Where is that? You with the order of blacklisting.
I was not given also a paper of instruction. That's why I am not prepared, my lord.
This flag B bring it.
Valid.
Mr. Das, learned additional comment advocate, that by letter number 4071 dated 21/3/2025, he has received written instruction from the district education officer and prayed for a short adjournment to put it in the shape of an affidavit. So let the affidavit be filed within 1 week, within a period of 1 week. Hence, serving copy thereof on Mr. Nandal on a counsel for the petitioner. Put up on 30th April 2025.
Grateful, my lord.
Item 11.
Petitioner, it is Sarpanch of Gram Panchayat. The Gram Panchayat body passed a resolution to prevent the manufacturing unit by the opposite party number 6. And accordingly, the petitioner filed reprehension before the public official, before the authorities, but no action was taken. So the petitioner compelled to file this PI.
Is the PIL maintained
Manner
for non-consideration of your representation? Is the PIL maintained?
the unit creating health hazards and so also pollution and public health is affected.
Then are you not an interested person? In PIL, you should not be only for the public cause.
Well, that is what the Gram Panchayat kindly see the Gram Panchayat
Are you a
body.
social activist?
My lord, I am the Sarpanch and the Gram Panchayat body passed the resolution appointing me to
So
take
are you not espousing your own cause?
No, my lord, Gram Panchayat
Because
body
Gram Panchayat, you are a Sarpanch.
unanimously the Gram Panchayat body passed a resolution. I am the Sarpanch. All the ward members unanimously passed a resolution.
Right. So you are also part of it. You wanted that resolution to be implemented.
My lord.
And then are you not an interested person? Because anonymously means you were also there.
My lord, I am the Sarpanch and the unit creating not only pollution, but also the farmers and farmers are affected. Crops, it is creating damage to crops and soil erosion.
But as a Sarpanch, can you, I am just asking,
My lord.
PI. You have a remedy, no doubt.
My lord.
But as a PIL,
My lord,
Maharashtra must do some 2014 judgment. You can find for PIL.
and by virtue of the resolution of the elected.
They appear to be very strict now.
Regarding maintainability, my lords, so far as
Don't get emboldened by that.
no, not by that much. So far as my instruction, my lord, the Tahsildar today he joined his duty because of the institutional training for 2 months. So he has requested for 2 more weeks to provide the instructions on the issue raised in the writ petition. So your lordship will allow me.
Just join one capital. Weeks.
Mr. Das learned additional government advocate press for further 2 weeks time to get the instruction stuff put up on 30th April 2025. Instruction, if any, shall be obtained in the meantime.
Item number 12.
Blacklisting of prisoner for
The blacklisting.
yes, ma'am. Without any notice. That is
without any opportunity of
yes,
hearing.
madam. That is the subject matter of.
So to my lord's order, I have already received the instruction. In fact, there has been a declaration column whether he is holding any kiosk in this Khurda road junction.
Sir, I understand. When you blacklist any person,
There has been notice. You know, twice he has been his EMD has been forfeited. Once he is holding up to 2029. I have having all those things which I can file in the form of an affidavit.
No notice has been.
Once he has been given.
sir, straight away one.
Sir, notice has been given.
About blacklisting,
No notice.
one of the primary condition is that you must serve them a notice. And thereafter, give them an opportunity of hearing and blacklist it. There is no difficulty. But the law is very clear on this point.
Yes, right.
Without following the principle of natural justice, can you blacklist any person by
If
one?
my lord allows me 3 days working day, I can file this in affidavit. Because I have noticed that on 1810 he has been intimated.
He was
He
served with a notice.
No notice.
Your lordship, let me file it.
Notice, he will produce it.
Let me file this on affidavit.
Issuance of notice will not do, Mr. Bharadwaj.
Opportunity.
Issuance of notice will not do. Service of notice is required.
No notice has been issued.
Then let me.
Opportunity of hearing must be there.
Then
Only
also
by
I-
serving notice,
with respect-
it will not suffice.
It is only a wrong affidavit on the basis that this has been done, and twice it has been done as per the instruction I have received. My lord may allow me 7 days.
Wrong
time, I can
affidavit
file this.
means wrong affidavit by the.
That he has not holding any of the.
That is the allegation. That is-
That is a different thing, Mr. Bharadwaj. That is on fact.
Well,
But fact remains admitted fact is that he has been blacklisted.
I'll specifically answer.
So 2 things have to be complied with. One is service of notice, another second is opportunity of hearing. Whether those 2 things have been complied with before blacklisting him. That is
I'll answer.
Mr. Bharadwaj learned CGC.
SS Kashyap.
Huh?
SS Kashyap.
Kashyap. Mr. Kashyap learned counsel for the your senior panel counsel or senior panel counsel. Submits that he has received instruction and will file affidavit within 3 days. Let the affidavit be filed within 3 days, serving copy thereof on Mr. Mohanty learned counsel for the petition put up on 22nd April 2025.
Okay.
Item 13.
Oh, if I may please your lordship, my lord, on behalf of Mr. Mishra, may I be permitted to address your lordships? Grateful, your lordships. My lord, Annexure 1 is an order passed under 33C2 of the Industrial Disputes Act, which is.
Why have you come here?
My lord,
Why have you come here? It's an ex parte order.
my lord, I'll just explain your lordship. My lord, on the face of. My lord, Lord, paragraph 3, if your lordships can just have of the impugned order, page 16.
What?
Yes, my lord, we have filed our documents, got it on record. We did not.
But sir, you did not appear and produce the. Tell me, is the pleading substitute of proof?
Not necessarily.
So you have to prove in support of the, give evidence in support of the pleading.
Your lordship.
So this is what we really wanted.
My lord,
And the court has said that you have not produced any document.
my lord, 33C2 is not maintainable at the first instance, my lord.
Correct, but you'll have to go and
Because-
say that why it is not maintainable. You'll have to show that what is the.
Well, there is no pre-existing award to be implemented. That is what is the stand. My case before your lordships is this on the question of
It's party, you could have gone there.
If your lordship relegates me back by setting it aside, I'll go and produce.
What's.
My lord, I'm only on that point. My lord, if it does, my lord, to take my.
A person who is a beneficiary of the order without hearing him can be set aside.
Lord, that is the problem.
Then
The workman will be.
Well, Lord, it is not maintainable. My
Maybe.
on
Maybe
law, my
what
lord.
prevented you to appear?
My lord, certain reasons I did not appear, your lordship. I bowed down, your lordship. That is there. But
You cannot drag on litigation like that.
my lord, I'm on the question of maintainability, just before or maintainability,
Maybe.
your lordships.
Maybe, sir. Read para 3.
Yes.
Only because you are set ex parte, your documents were not taken into consideration.
Your lordship.
So you pray for setting aside the ex parte order so that your documents can be taken into consideration. So cause will be taken into consideration.
Lordship.
What is wrong in it?
Your lordship.
Anything else, Mr.
No, my lord, I am only on the limited point of the Honorable Apex Court's decision that 33C2 at whatever has been filed could not have been entertained. On the case, whatever is on the pleadings on record, that could not have been entertained and award could not have been passed.
Look, there is a difference between 33C1 and 33C2.
Your lordship.
33C1 pre-existing right.
My lord.
33C2 entitlement.
Yes.
The industrial adjudicator will go into the question of entitlement. So in this case, the industrial adjudicator, it is only unpaid salary.
My lord.
So it is pre-existing.
My lord, my respectful submission would be to the contrary.
Maybe you can appear and file an application for setting aside ex parte order. Why a workman will be summoned to this court for that?
My lord, because I did not plead, although I've annexed my show cause, it would be of no relevance. But if I could only satisfy on maintainability, I would have a case before your lordships today.
So you want to reduce this court to an industrial adjudicator?
But on the point of maintainability, beyond that, nothing else. Subject.
What prevented you to raise that question before the issue before the labor court?
My lord, we had raised the issue, but we did not appear.
Exactly.
Your lordship.
You have filed your show cause and left the court.
Your lordship.
You didn't appear.
Your lordship.
So you will have the luxury of not appearing before you are feeling shy to appear before the labor court or what? Being the management.
No, your lordship.
Then
may try and for once, if I can try and satisfy your lordships on maintainability, subject to your lordship's appreciation, or else I'll be relegated back.
Why should we, why should we delve? That may seal your fate.
Lordship may relegate me back.
Where is his speaking? On the side speaking, well, you have not annexed.
No, these pleadings have not been annexed.
So
that is there on record in the.
how do we know what you are saying, maintainability on the basis of your statement?
My lord,
Show us from his statement.
my lord, it is as per the impugned order itself. Your lordship will see that. It starts with.
We have gone through it.
Yes,
and
Lord.
the court has said, the Labour Court has said
My lord.
that since you have taken those points
My lord.
and since you did not participate, so I will not look into any defense which you have taken.
Your lordship.
So he has not said anything.
My lord, he has accepted the claim as it is.
No,
that
no,
there is
no,
a-
no, no. He did not say. I got your point. What you are going to say, that he does not satisfy the definition of a workman. He was holding a managerial post. This is your point.
My lord, I am on the part that the reference to be referred has not been done and his remedy lied under section 10 and not 33C2.
Then
That is what I would want to argue before you.
no, then you are wrong.
My lord, workman is not even there. My lord, workman because
I
it's
was
not.
thinking in a different way.
My lord, workman 33C2. My lord, workman, that definition, your lordship is right. That is my points on merits.
Not merit. That's a the appointment letter will speak.
Yes, that is there with your lordship.
So,
My lord, the appointment letter is there.
but show us that he has admitted that he was appointed.
Yes. Your lordship
Where
will
is
see.
his pleading? You have annexed. You have not annexed.
My lord, from the impugned order, your lordship will see
No,
that.
no, impugned order is silent. Please read it.
My lord would see engagement order by the opposite, page 16, paragraph 2. The case of the applicant as depicted in this claim application in brief is that on being selected to the post of community mobilizer through a selection process conducted by the opposite party number 1, he was issued with an engagement order by the opposite party number 2. Why did letter number this for 1 year? And
What
why
is the role? Then whether
Yes.
it comes within the purview of the workman, discharge of the duties, what was his duties, everything
Yes,
he
my
must
lord.
have stated in his petition.
My lord, may I take leave to file that application?
Nothing.
Petition.
Then you wanted.
My lord, because
What
I
has
can,
accepted is that he is a workman.
my lord, the engagement letter will speak for itself, which I have annexed.
Engagement is also not, engagement letter is also not.
My lord, page 37 is the engagement letter.
I do not find it here.
Page 37, your lordship.
Only the show cause, this is the.
My lord, annexure 2, I have annexed it in my show cause at page 37, which I filed with you.
I am not getting it. I'm not getting it. Oh, these are the part of the pleadings.
My lord,
This
this
will not do because you'll have to prove it.
your lordship.
This is, please try to understand. My lord. We do not want anything from your end. We want from his end that he has admitted. Then an next party we can go.
Your lordship. My lord, may I file that pleading, my lord? May I bring it on record? May I bring his?
No. You go there.
Your lordship, my relegate.
Seek for setting aside.
Your lordship, my relegate.
Do you want to seek for withdrawal?
Your lordship.
Without inviting any observation.
Your lordship may kindly direct them that they would look at it sympathetically for my recall application.
So, Saurabh, you should. Petitioner in this writ petition 6-2 set aside order dated 11/7/2024, Annexure 1, passed by the Labour Code Bhubaneswar, passed by Labour Code Bhubaneswar in ID miscase number, Industrial Disputes miscase number 32 of 2020. Filed by the opposite party number 2. Step. In course of argument, Mr. Saurabh, learned counsel for the petitioner, being authorized by Mr. Mishra, learned counsel for the petition. Mr. Saurabh, learned counsel, being authorized by Mr. Mishra, learned counsel for the petitioner, submits that interest of justice will be best served if the petitioner files an application to set aside the ex parte order under Annexure 1 passed by the before level Bhubaneswar. Step. He therefore prays for withdrawal of the writ petition. Step. In view of such submission, the writ petition is disposed of as withdrawn with a liberty to the petitioner to file an application on for setting aside the impugned order, file an application before the Labour Court Bhubaneswar for to set aside the impugned order under ex parte impugned order under Annexure 1. Step. While considering the application for condonation of delay, granted Labour Court may take into consideration the pendency of the writ petition before this court from 25. When did you file?
25th February
to 25th February 2024 till date. The writ petition is accordingly disposed. Writ petition is accordingly disposed of with the as withdrawal with the granting such liberty. The petition is disposed of as withdrawal with the following observation, with the aforesaid observation.
Item number 14.
Let's first sub-item.
Vendor.
What can be done? Now there are laws, there are schemes, everything is there.
First,
In 1984, the first judgment came on the street vendors' right. Right of a hawkers is implied in the fundamental rights.
We'll get illustration.
They have applied for the street vending certificate, my lord, that is pending before town vending company.
Now there is a rule which has come. Now the rehabilitation that has to be done for you. Some scheme you have to.
Odisha scheme, 2015.
So now right under 19(1)(a).
2016 Act also provides that.
14
Act, yes.
14 Acts and rules 2015.
Similar to the other petition that was just listed last week, you know. So, what has been passed?
First matter can be disposed of in that like because in first item that
you have not yet provided with street vendor certificate license.
First matter can be disposed of, that is 6335 can be disposed of in that light. Annexure 2 series is pending records. No, second is same here, but here the petitioner has a document to establish his claim as a street vendor. Second. My lords. First matter can be disposed of in that light. My lord, second matter in item number 14, that is 6079.
Here they have the petitioner has the
Certificate of trade license, which is.
You can observe that.
My lords and lordship may observe that and I may be protected. The lordship may come to annexure 1 series starting from running page number 11, my lords. My lords, observing section
3 and 18, my lords.
No, your license period is over. It has expired.
My lords, that has been expired on 31/3/2024.
2024.
My lords. And subsequently, I have recently applied for issuance of street vending certificate. That is at Annexure 2 series, my lords, dated 16/2/2025. And my lords, if my lords may come to turning page number 19 is the endorsement. Acknowledgement.
We're talking about WP 6079.
My lords, yes, my lords.
That application, they have included all the documents.
My lords.
Yes.
Trade license and all.
So take it to consideration.
Take that in. My lords, and till then I may be protected, my lords.
The petitioner don't have the.
Mr. Mohanty, in that case, their position should be protected. The first
The
is that
second matter.
it's in the second matter, we are 6079. Where first state petition can be disposed of in the light of the order.
Mohammed.
Protection has to be.
Yes, my lords.
Motion grant protection until disposal of the application.
Second protection has to be given. The same line, it will be disposed of.
But protection.
Over the occupation, over the place where he is running his business of
Cosmetic shop, my lord.
cosmetic shop and earning his livelihood. Stuff. Para. Mr. Mohapatra and counsel for the petitioner submits that the petitioner is a street vendor and has been granted certificate of trade license on 3/9/2023, which was valid till 31/3/2024. Stuff. Even after expiry of the license period, the petitioner is running his business without any objection from the Bhubaneswar Municipal Corporation and is earning his livelihood.
Issuance date is 1/8/2020. I may be pardoned, my lord, as certificate of trade license issuance date is 1/8/2023.
1/8/2020. Okay, 1/8/2020, which was valid up to 31/3/2024. Very recently, the petitioner came to know that the Bhubaneswar Municipal Corporation is contemplating to evict the petitioner from the place, that is where you are running.
My lord, unit 2.
Unit 2?
Unit 2, my lord, ward number 40, unit 2, Ashok Nagar Market Building.
Where is that? Where is that?
My lord, come to Annexure 1 and 11, trade
Yes.
address.
Oh.
Certificate is mentioned. Trade address.
Ward number 40, unit 2.
from the place, that is ward number 40, unit 2, Ashok Nagar Market Building, Bhubaneswar. Sir. Hence, sorry, it is further submitted that the petitioner has made an application for renewal of his trade license.
Issuance, madam.
For
Issuance of street vending certificate.
Issuance of street vending certificate on
16/2/2025.
16 after filing of 16/2/2025 in proper format to the town vending committee, opposite part number 3, which is pending for consideration. Step. Mr. Mohapatra, learned counsel for the petitioner, therefore submits that if the petitioner is evicted in the interregnum, then he will be highly prejudiced and lose his livelihood. Step. He therefore submits that the possession of the petitioner be protected till his application for grant of street vending license certificate is granted by the town vending. His application for grant of street vending certificate is considered by the town vending committee. Stuff. Bhubaneswar Municipal Corporation. Stuff. BMC. Mr. Mohanty, learned counsel, appearing for the Bhubaneswar Municipal Corporation, submits that the petitioner is unauthorizedly occupying the place where he is running his cosmetic shop. Due to occupation of the petitioner, there happens to be traffic congestion, and the Bhubaneswar Municipal Corporation is facing difficulty in sanitization stuff. He, however, submits that if an application for grant of street vending certificate is pending for consideration before the town vending committee, BMC, the same shall be considered in accordance with law. In view of the content, taking into consideration the submission made by learned counsel for the parties, this court, without expressing any opinion on the merits of the case of the petitioner, disposes of the writ petition with a direction that the town vending committee, Bhubaneswar Municipal Corporation, opposite part number 3, shall take into consideration the application filed by the petitioner for grant of street vending certificate under the provisions of the street vendors within bracket protection of livelihood and regulation of street vending bracket close Act 2015 and rules as well as scheme framed thereon, as expeditiously as possible, preferably within a period of 4 weeks.
4 weeks.
Within a period of 4 weeks from the date of production of certified copy of this order. Till the application under Annex 2 filed by the petitioner is considered by the town vending committee, he shall not be evicted from the place where he is running his business. Writ petition is accordingly disposed of. I am grateful.
Item number 15.
Item number 15, my lord, same as this item, only in place of certificate of trade license, my lord, it would be provisional certificate of trade license, my lord, which expired on, my lord's, your lordship may come to annex, running page number 11.
Now, what is your nature of business?
My lord's helmet shop.
Helmet shops,
my lord's. In place of vending the
establishment you see from where you are running your business. Have you seen that? How can you claim a street vendor?
My lord, your lordship may come to.
His establishment is situated over what? Private land, not on the public land. Page 20.
Page 11.
My lord, because they're not issuing trade license itself, just to.
Then how can you take advantage of this?
Oh,
If you are running on a private land.
private land, you
then
cannot be a street
it's
vendor.
a street vendor.
My lords may just see that the trade address, my lords.
No. Mr. Certificate of trade license,
My lords.
annexure
One.
at page 20. Come to page 20 of your thing.
Same certificate in annexure.
No, we have checked, over 14, not the same certificate.
No, my lords. Not that the
Oh,
same
that
as
is the
14.
difference.
My lords.
11
11 and
and 20.
20.
Private land.
Yes, my lords. It is mentioned that it is in the private land, my lord. My lords may just come to trade address in the seat. It is in front of Jalimunda Sai RTO, my lord.
But in front of such and such, maybe on a private land in front of
My
that.
lords may
That is the difficult.
direct that they will obtain instruction whether it is on a private land or a government.
What instruction is there? What instruction, further instruction will take?
My lord, with regard
It is on the private land.
My lord, private land, because trade license in the present time, my lords, they are not issuing on government land, my lords. The BMC is not issuing on government land. The lordship.
In item number 14, it was issued.
It was, my lord, that
was no,
that was
column
prior
like
to
this.
that was prior, my lord.
Then this column would not have been there.
My lords.
This column would not have been there.
My
Then
lord,
private
it was
land.
not there, my lords. In that certificate, it was not there prior 2024, my lords. 2000 and recently they have added this, my lords.
This was issued on 23 to
25, my lord. And they have added.
26 to 2025. Lead personal filed in 28 to 2025. Application page 14
Given only for 15 days.
26 to 2025 application was given. Lead personal filed on 28 to 2000 and only 2 days after.
They were unaware about the provision how to apply, my lords, because it is the town pending committee who shall.
Mr. Mohapatra,
my lords. My lords, may come to section 3, my lords, of street vendors.
Are you a street vendor? If your trade license shows that you are vending from a private place? Just simply ask. What is the definition of a street vendor?
My lord, who has a vending business in the street, my lord.
So if it is done from a
private land, my lords, then I do not have any case, my lord.
Why you took the trade license? You've taken advantage that we should.
My lord, to show that I'm running a business, my lord, sir, because I do not have any, and I have specifically averred in my rate petition, my lords, that although the present petitioner does not carry a street vending certificate or any trade license, and that has to be done by the town vending committee. Your lordship may just come to section 3, my lords.
This case is a different one.
My lords may just allow me to go through section 3, my lords.
Yes, please go through.
My lords.
Please.
Section 3.
First, you come into the definition section.
2L.
Yes, my lords.
Come to the definition
My
section.
lords. Street vendor means a person engaged in vending of articles, goods, wares, food items, or merchandise of everyday use
in a street, lane, sidewalk, footpath, pavement, public park, or any other public place.
My lords. Or private area, my lord.
Yes, that is a different one.
My lords.
So,
my lords, and your lordship may come to after that page, my lord. Survey of the street vending vendors. If the lordship is on the same.
Yes.
The town vending committee shall, within such period and in such manner as may be prescribed in the scheme, conduct a survey of all existing street vendors within.
Great. Survey of who?
The street vendor.
If you do not come within the purview of a street vendor, then why they will do a survey?
Because my case is they have not conducted any survey to establish that I am a street vendor, my lords.
So how street vending certificates have been issued to others if they have not conducted any survey?
In this area, street vendor certificate has not been issued. In this area.
Where is your averment to that effect?
My lords.
In the writ petition.
No. But paragraph 9 I have stated, right, although the present petitioner had applied for street vendors application recently in accordance with the scheme, but is carrying on his business since long in the said area.
It is not that no survey was carried out in the area where you are running your business. You made that submission, na? Yes, source that averment in your petition. Sir, you cannot develop your argument like that.
Is not
It is a factual aspect. Cannot.
That cannot. Then not dispose of.
Alright. Well, better. You want to withdraw or will you dismiss it? Okay, if you dismiss it, then
no.
Your state application, you don't debate.
That may be considered mallet. Annexure 2Cs may be considered.
Petitioner in this writ application press for the following relief. In course of argument, Mr. Mohapatra and counsel for the petitioner press for withdrawal of the writ petition to pursue his remedy with the town bending committee, Bhubaneswar Municipal Corporation. Before the appropriate authority, Mr. Kondal and counsel for the Bhubaneswar Municipal Corporation does not have any objection to this, as the writ petition is disclosed of such withdrawal.
Item number 16.
I'm good.
Contractor. 5,000 rupees you have now. 5,000 rupees is not a matter. On the imposition of 5,000 rupees, they have debarred me from a prices class. That is the question, man. For that purpose, I am not for 5,000 rupees. Only on penalty of 5,000 rupees, they have engaging you, sir. And they have debarred me my prices class, which I am entitled to 13 lakhs. This is the question. This is covered by Radhashyam Alba's case, my lord. In the last occasion, my one friend has taken time for taking instruction whether it is covered on Radhashyam case, my lord. At the time of post facto approval, they have imposed a penalty without any intimation to payment. And that is the Radhashyam Alba's case that is covered by this case, my lord, that is confirmed by the Supreme Court. The state has gone to Supreme Court.
Last occasion, you have taken time, Mr. Tripathi has taken time. The
Supreme Court has confirmed this.
Everything was found. The price escalation, everything was found to be in his favor. But suddenly only ground is beyond the time completion.
Yes, ma'am.
Beyond the completion, 5,000 rupees is.
Beyond the completion, the work was completed after 6 months of the stipulated period and are allowed to complete. And after completion of after 6 months, at the time of post facto approval and payment of that bill, that have deducted 5,000 with an intimation and sent the balance amount to my RTGS to my account. Subsequently, I find that 5,000 was imposed and verification of that applied for RTA and the RTA application they have intimated that has been imposed for delay in work and for accordingly your price escalation rejected. The price escalation bill has been you have rejected. That cannot be paid.
Where is that?
That is on 8/1/2024 manner. The page
Annexure 3.
Yes, ma'am. Annexure 3 manner.
Page 23.
Yes, madam.
The last part, hence the price adjustment claim submitted by you is irrelevant and not
What is the
adjusted.
amount? Because they have said that the first RA bill and the second final bill has already been paid.
Yes, ma'am. At the time of filing of the payment of second arrival, that is 17/12/2021, that was 6 months of completion. At that time, they have deducted 5,000 without any intimation.
That is what I'm saying. You are saying that apart from 5,000, they have adjusted only 5,000 rupees.
Well, but on imposition of 5,000, they have deducted getting my prices study because since they work.
The price adjustment claim submitted by you is irrelevant.
Again, and not admissible as per provision of contract. That is only due to the imposition of 5,000. But price escalation clause is there in the agreement.
Yes.
But that has been rejected only on the ground.
So I have not filed any counter, but there is nothing on record to show that extension of time was granted to the petition. There is nothing on.
You have paid the final bill after the period expired.
So accordingly, penalty has been deducted.
The completion has been done on page 22.
Where is the terms of the contract?
Yes. Price escalation.
Whatever.
Yes, not price of.
Yes, ma'am. We are look to page 15. Page 15. Clause 31. That is price escalation. Page 15.
Yeah.
Clause 31. Price escalation. The formula is there and all these things.
No. There is a clause stipulating the time limit within which it has to be completed. There is a period which is provided.
What period?
Yes, madam. Let's read page 17. Page 17, and last part. In the terms of the aforesaid escalation clause, where the period for completion of the work is as stipulated in the agreement is less than 1 year, no escalation admissible. In case where the stipulated period completion is 1 year or more, escalation of account price variation would be admissible only for remaining period after excluding the first 1 year period thereof, provided the work has been carried by the contractor in terms of the relevant provisional agreement. In the situation where the period of completion is initially stipulated in the agreement is less than 1 year and subsequently the completion period has been valiantly extended on the ground that the delay in completion work is not attributable to the contractor and the result of the total period including period extended period stands at 1 year or more, escalation is admissible only in the remaining period after excluding the first 1 year.
Where is that valid extension? Where is that valid extension of your contract period?
They have extended, that has not been intimated to me. But after completion of the work, but they have posted for that purpose. I am applied for when the extension has been, they have not allowed me, they have not supplied me, only the 8-1 letter was given at the time of payment that has been.
Sir.
The post facto extension was given after completion of the work. And this is the provision until unless the extension has been granted, a regular payment cannot be made. And that for that purpose, you are look to page 22.
Mr. Mohapatra, please.
Understand. There are two things which you have to satisfy us. The first thing is that this contract, which was awarded to you, is beyond 1 year. Secondly, the final bill which you submitted. After, now the question is whether those were submitted after the completion of the work beyond the period or within the period.
Let's look to page 22.
You got it? What I mean. Suppose, take for example, suppose the contract says that you have to construct or complete the work within 1 year, 6 months.
Yes.
You completed the work within 1 year, 9 months.
Yes, ma'am.
3 months beyond.
Yes, ma'am.
But you submitted the bill, final bill for that after 1 year, 9 months, and they paid it, including the work which you did after 1 year, 6 months.
Yes.
One can visualize that it is an implied extension of the time by time.
Right.
If it is an implied extension, then we can hold them up.
Yes.
That how can you do it? Here, one very startling facts have come. They admit that the final bill has been paid when you submitted the fund.
I have submitted the final bill after 1 month of the completion of the work.
When you completed?
Well, that is the page 22. They have given the completion certificate on 7/6/2021. 7/6/2021.
And when the original period expires?
Expire original period is 2/6/2020.
So even 1 year?
Yes. 1 year after the initial period of completion, 1 year more has been taken for completion of the work. That is there. The completion certificate is in page 22, madam. They have issued
And then the entire bill is paid. On the original price, it is paid.
Original price has been paid. But the price escalation not only not paid because of imposition penalty. Because there is a scope in the terms of the price escalation clause.
Where is the provision for a penalty?
Penalty provision. Sorry, my lord, I have not given the entire agreement. That is clause 2 is there, my lord. Clause 2 is the penalty provision.
So that is what we have to say.
Yes,
It has got any nexus to this.
Yes, madam. I pray for 1 week. I will submit the total entire.
So that is your foundation of.
Yes, madam. The entire clause has not been filed, madam. Entire agreement has not been filed. Penalty is for under clause 2.
Whether this penalty has any nexus to it.
Yes. I understand your point, madam. I look 1 week time.
It is Mr. Mohapatra, learned counsel for the petitioner, raised for an adjournment to place on record the copy of the complete copy of the agreement executed for the work in question. Sir, when can you produce? Sir, when can you produce that was?
1 week after any date.
Next. 23rd. Put up this matter on 25/4/2025.
24th, sir.
25.
Item 17.
Petitioner had initially challenged petitioner the leaseholder of several leases. Initially, she had challenged the release, the rule 32 2 of the minor concession rule. That they are asking the provision under which they ask the entire 1 year's advance entire quantity in
royalty.
Entire quantity at one shot, which Maharaj was challenged on the ground that no, this is not what is provided in the Central Act. MMDR Act doesn't provide. Therefore, this falls foul of the ultra-vires the main act. Anyway, Maharaj, that issue was not decided. Eventually, also till date, it's not. It remains undecided. But Maharaj, the Honorable Court said that you deposit, will make installments to deposit. So accordingly, the court fixed up the installments for the deposit. Now, before my first installment, I already managed 25% of the deposit, that is around 28 lakhs. They are lying with the state government. Now, 7-8 days prior to the deposit of my 50%, my lord, your lordship may kindly come to page 162. Page 110. Page 100, annexure 10 series. My lords, my deposit falls due on the 2nd of February. Now I write to them regarding the query agreement of Dankari BSQ number 15.
As per order, dear sir, as per order passed by the Honorable High Court of Orissa on dated 19/1/2023, we are prepared for the query agreement as mentioned above. I have 3 queries. The other 2 queries, there is no issue. I deposited as per the my lord's direction or mandate of the High Court order. The other 2 have been deposited. I'm working there. Now, this particular query, my lord,
You are pressing the first.
is the issue. 15 is the.
No, sir, you are pressing the first petition.
Madam?
There are 2 petitions. Which one you are pressing?
I'm placing the first one.
First one.
First one.
You said 110, at page 110.
Page 110. Annexure 10 series. So I informed them.
Yes.
I'm sorry.
Yes, please.
Yes. Your Lordship, come.
Yes, please.
So I told them by depositing 50,000, we are ready with the amount. Then, my lords, on 27 January, that is 2 days thereafter, this is the letter I found. My lords, this is crucial. Dear sir, we have conducted a team visit with the geologist to the said query site to look into the development work. And we have found that most of the area is covered by water. At least
Which one? Page.
Page 111. The next page. I'm sorry, madam.
No. Yes.
Page 111.
Yes.
We have conducted a team visit with the geologist to the said query site to look into the development work. And we have found that most of that area is covered by the water, at least 70-80% of the total area, which is not viable for us to go for agreement at this time. Hence, before going for agreement, we are requesting you to kindly do a proper demarcation of the said query and let us know. Then, manners, the next letter, next page, 1 page thereafter, manners, 113. I again write to them on the 1st of February. This is to inform you that we have already issued a letter regarding the demarcation of the said query, DSQ number 15 on 27/1/2023, as most of the query area is covered by water, at least 70-80%, which is not viable for us to go for an agreement at this time. Therefore, before going for an agreement, we are requesting you to kindly do a proper demarcation of the said query to let us know for further processing. Now, this is not, I'll tell you, Your Lordship, what is exactly happening. Your Lordship may kindly come to this map. Map, Your Lordship, finds at page 95. 95, annexure 9. I just extracted that portion, Your Lordship will find. The entire blue portion is, my lords, what is the water? 95, it's a map like this. Page 1. No.
Is it there at page?
Sorry, I'm sorry, 107 probably.
That
That's what my question. I'm sorry, my lord. It's a gap between filing. My lord, Your Lordship, this was what was granted to me. Out of this, Your Lordship may kindly appreciate. What must
Yes.
Ma'am, the entire blue area, Manoj, Your Lordship, is 70.
The water body.
Ma'am.
Blue area is a water body.
Water body. Entire. So then thereafter, I was beset with a personal problem. My husband fell seriously ill. So for 1 year, I could not, he had to undergo, he had to kidney failure. So it started progressing very rapidly. Then he had to go undergo an operation. I filed all those papers before Your Lordship. Now, after coming back, I again approached them and I gave them this letter, 158 minutes. Here I have clearly explained to them that this is the query, page 158, annexure 18. Request for permission to relocate the query operation due to safety concern. Now that query it was not even possible to scientifically work, not possible to practically work also, man. Neither to create the benches, not even to turn the machines. Nothing could be done on that small patch of available land. And the rule is that you should give me a mineable area. There has to be some quid pro quo. I pay you the money, but you have to give me some area which is mineable. Now, this second paragraph. When we visited the I'll start from the first.
BSQ 15, yes.
When we visited the BSQ 15 site prior to the tender auction with the respective revenue inspector and other relevant person, we were shown a workable place and a non-demarcated area. This was the reason for our interest and participation in the tender. And after that, we got selected as successful bidder on October 2017. However, upon approval of the mining plan on 31/1/2022, and during ORSAC team came for proper demarcation of the said lease area, at that time, it came to know that lease is covering at least 70 to 80%.
Reiterated what you took as standard.
And then, my lords, they did thereafter, my lords, after this letter was given, my lords, on 11/11/24. Then, my lords, that is then, my lords, on 3/2/2023, your lordship is page 162.
Yes.
Suddenly, my lords, in WhatsApp, not even the address to me, it was not even given to me in any official, any formal, any my lord, kind of a communication. On 3/2/2020, my lord, 23, a letter has been issued by the Tahsildar, the then Tahsildar, cancelling the lease.
Forfeiting your security.
And this letter is now being served on my representative through a WhatsApp after a period of 2 years. Now, on 8/3/2020, my lords, 5. Now, my lords, what is wrong with this order is this, my lords, that the order is completely lacking jurisdiction. Now, my lords, I'll take your lordships to the, my lords, besides the fact that it has not been communicated as, my lords, in the due process, and this is no communication in the eye of law. There's no proper communication. Order itself.
Tata Cellular.
My lords,
Tata Cellular judgment.
Tata Cellular. This is, my lords, that I'm arguing it is, my lords, on the face of it, the order is void. Goes to the root of the matter, my lord. Your lordship may kindly come to, my lords, amendment. These minor on, my lords, 27th December 2022. Your lordship finds that at page 152, annexure 17. Now, by way of this amendment, my lords, the minor mineral concession, which was previously, my lords, the authority was the my lords, authorized officer and the, my lords, department was the revenue department to deal with. Now, my lords, after the amendment, they took it out of the revenue department and my lords,
vested
in the mining department. Department of State.
So mining officer is the competent authority. You need to say that.
And this authority is assumed.
Where is that?
Where is that amendment?
Amendment is at page, my lords, 152, annexure 17.
Yes.
Which one? Mining officer means
Director of Mines and Geology or any officer duly authorized by the government in writing. Director means, my lords, the Director of Mining and Geology. And my lords, your lordship, page 156. Competent of schedule 4. The schedule itself has been amended. Your lordship drops down to the second one. Minor minerals other than specified minor minerals when occurring within village boundaries. A, B, when occurring within forest area. Mining officer of the respective jurisdiction. Now, earlier, this was Tahsildar, who had the authority and the jurisdiction. Now, this jurisdiction of the Tahsildar, this came in on in 22.
27 December.
27 December 22. Yes. And thereafter, the next page, on 157. 1st February, consequent upon transfer of the subject, minor minerals, to Steel and Mines Department, White so-and-so department notification so-and-so, Directorate of Minor Minerals, Orissa, functioning under the administrative control of the Revenue and Disaster Management Department, is hereby transferred to the administrative control of the Steel and Mines Department with effect from 1/2/2023. Now, the order by the Tahsil that has been passed, Your Lordship, was, may appreciate, my lords, on 3/2, 2 days thereafter. So he doesn't have, on the date of passing of the order, he doesn't have the requisite authority, my lords, under law to cancel the lease. That is the, my lords, ground, basic ground on which, my lord, this order is being challenged. Now, the legal traction for that is my first prayer in the writ. The second prayer, my lords, Your Lordship may come to the second prayer, to relocate my mines within the same plot with, my lord, a mineable area. That, my lord, the legal traction is there in the rules. Your Lordship may kindly take up the rules. 28(8). Rule 28(8), my lord, of the Mineral Concession Rules. My lord, Justice Mohapatra. 8. A holder of a query lease. Now, my lord, I'll take a pause here and take your lordships to, my lord, the first the preamble. These rules, your lordship may kindly come to the preamble. In exercise of the powers conferred under subsection 1 of section 15 of the Mines and Minerals Development and Regulation Act 1957, and in supersession of the provisions contained in the Orissa Minor Mineral Concession Rules 2004, except as respect things done or omitted to be done before such supersession, the state government hereby makes the following rules for regulating the grant of mineral concessions in respect of minor minerals. Now, these rules, my lords, have been, these are, my lords, enacted under the provision, my lord, the source is
rule-making power
under 15.
From 57 Act.
57 Act, rule-making power. 15 of the 57 Act.
Right.
So, my lord, why I'm referring to this here at this point, my lord, this will have some relevance as I proceed further, my lord. 28(8). Your lordship may straight away come to rule 28(8).
Modification.
Modification of the man.
Yes.
A holder of a query lease desirous of seeking modification in the approved mining plan for query lease as considered expedient in the interest of safe and scientific mining, conservation of minerals, or for protection of environment shall apply to the authorized officer, setting forth the intended notification and explaining the reasons for such modifications. Now, my lords, my prayer can be granted under this rule by the authority. My lords, for better clarification, my lords, your lordship a question might come from your lordship as to where is the power for change of lease area? That specific prayer that I'm asking. Well, that your lordship will find at section 22E, rule 22E of the Mineral Concession Rules 1960. The Mineral Concession Rules, my lords, are a set of rules which have been formed. Lordship may kindly have the MMDR Act. MMDR Act. Page number 37 of the book, probably your lordship is referring to. Is it the 22nd edition, 2022?
2025. You are far updated.
This has not changed. I bow down, things have not changed much.
Which rules?
My lords, Mineral Concession Rules, Rule 22E.
1960.
1960. Mineral Concession Rules, 1960.
Modification of approved mining plan,
22 capital E.
E, capital E.
Yes.
Subject to the provisions of subrule 3, in case of any modification of the approved mining plan, the project proponent shall submit the modified mining plan in accordance with 22B for approval of the officer or authority notified under section under subrule 6 of rule 22B. Modification under subrule 1 shall be on any of the following grounds, namely, malabs, straightaway your lordship may come to 3, change in leased area. So leased area can be changed, malabs, with the subject to the approval of the authorities, they can be changed. So all that I'm asking your lordships today, for your lordship is this, malabs, the cancellation order we set aside as malabs, non-est and void when it goes to the root of the matter, ab initio void, the eye of law. And my lord's prayer, I may be remanded, this matter be remanded to the DDM now. Now the mining officer and DDM is the authority. To my lords take a fresh call under rule 28.8 of the
28.8 read with.
Yes.
Read with 22E of the
mineral
concession rules 1960. And that will solve my problem. And my money is with them. And now also I am ready with the balance. 80 lakhs I am ready. My money minus 28 lakhs is lying with them.
Before my friend started, my lord, I submitted to your lordship that I have not been able to find a counter. Well, the notice issue.
No. He is going by whatever is the admitted document. His first point is that the Tehsildar who initiated a proceeding passed an order 2 days after that notification came, amending the act whereby and whereunder the power has been transferred to some other authority.
I have to see
So
my
he says there's a lack of access to jurisdiction and power, so it's a nullity.
I only pray, my lord, your lordship may allow me to examine as to whether there is saving clause or not. As to pertinent questions have been raised by my lord.
He says that the modification I sought for, you have to take a call, you have to take a decision.
Certainly,
permissible under the law. Now, whether you will accept or you will reject, at least you take a decision.
Certainly.
And they are not prejudiced by it.
I may come up with a counter affidavit that whatever my learned friend says is correct.
No, it's a pure question of law, sir.
Yes, my lord. I don't dispute.
Then what counter?
No, counter in the factual side.
It's the factual side. Tehsildar admittedly passed an order cancelling and forfeiting the security deposit.
Reason being, my lord, on the earlier occasion,
whatever be the reason,
my lord,
but the authority, if it is taken away by virtue of law,
there I cannot.
Can he pass an order?
There I cannot have
functors of issue.
Only for a moment, your lordship, if your lordship
is it? That is your case.
That's me.
Whatever
functors of issue.
Question of law, I cannot have a dispute over there. Only 107 pages.
Till now, he has not communicated the order.
The order which was passed by this honorable court in the division bench, it is available at page 107. There a direction was there, on consent of my learned friend, that certain amount will be deposited by a certain date and rest of the amount will be in installments. That he having failed, it has been cancelled by the impugned order. Certainly, impugned order has been passed by the authority who doesn't have the power after that amendment came. Over there, I cannot have any dispute.
Then it has to go.
It has to go, but at the same time, the lordship's order is to be respected also.
No, that is a different. The money is lying with you. You have not only cancelled the mining lease to them, but also forfeited this security deposit. So, by this order, if this order goes, then the money remained with you. Now, the new authority who has come, he has to take a
call on 28.8.
Money is with us, but that was deposited after the deadline fixed by the
That was before. 25% initial deposit. Initially. Under 27 rules. Kindly go through the rules, minimum concession rules. Moment I get the tender,
I'll give 1 week time. I'll confer with 1 week back, sure. I'll just have a telephonic talk with the officers.
You are the person who can take a decision on the proposition of law.
Proposition of law, no question of it.
This is what is the first point is.
I am-
Second point, he does not want that you should decide because the authorities are vested in the power to take a decision.
Deputy Director minds.
Notification.
Man.
Whether you may allow, you may not allow, it's up to you.
Man.
You have not taken any decision thereupon.
No, that information is not with me right now.
No, they have not.
That is why I am praying for a.
So he understood what he really wanted. First point, we will simply direct you to take a call on that.
Why I was saying, before you're working direct, possibly.
So we are conscious that second prayer, why he insisted.
I am conscious, brother. I am conscious. I understand what my learned friend's argument is. I think.
We pay the entire outstanding also if they. I'm ready with the entire money. Even then I was ready. But I could not have mined in water.
I think while in
The requirement is
interim,
scientific.
some order must have been passed by the deputy minds with the authority now under the new law.
After cancellation, how can he revise it?
Cancellation passed by different officer.
So that is why. So you already cancelled. How can it be revived? Can it be revived?
The only option with the deputy director of mines is to reject his application. Or modification of the.
Communicated by WhatsApp, and there is such an order in the
That
file, it
since
is not
your
into my
parent
representation.
lease has already been cancelled.
Then your
Then
modification of.
Modification does not arise.
That is. Unless this order goes, my lord, the other pair.
Please consider what is hidden in his mind is trying to extract it this way. So we will set aside the order of cancellation, directing the authority if they want to initiate. We are not going to say anything on this second prayer.
Second prayer
Second,
cannot.
actually give me the liberty to pursue with it.
We will not say anything on that.
Will not say.
Since your lordship is
But by Mr. Palit, by setting
But
aside
that second prayer is there in the
If this amendment has come and the authority is vested upon others,
second read.
admittedly the order is passed after
That is
that.
the order, and that is
What
the prayer, the
remains?
second read.
It's an open and shut case.
Second read, that is the
There
prayer.
is
Let the other authorities
in our High Court
consider.
What?
In our High Court rules, there is a provision. If your lordship can dismiss the case at the first room. But if your lordship is allowing a writ or allowing it, right, that language is in that event, one opportunity should be granted.
So we are giving an opportunity of hearing. Does it, I do not know. Does it say that the counter has to be filed?
The counter, that
It's
what
a
is not.
pure question
That
of.
what is not.
So we are giving an opportunity, sir.
Counter what is not there.
After that, what is your concern? It's a law point, sir. Otherwise, we would not have said. If it is a factually, we have given a lot of time that you take an instruction because it requires a factual instruction to come. And this order is dated such and such. Amendment is dated such and such.
There cannot be any dispute. Amendment came before and the
That
order
is
has been
what we are thinking.
Your lordship.
That's the only thing which troubles
Your
us.
lordship.
Otherwise.
Yes.
What is this connected?
Connected case.
Connected case where I prayed for the second pair. That was the first case. 24.
That is with regard to 24, 28.
Cancellation has been done, no.
No, then there was no communication of the cancellation order.
There is no cancellation.
No,
in
that
this
time there
matter.
was same.
No, that time.
There was no communication.
What is the present scenario as of today?
Present scenario is of today. This was 24. Now 25, this cancellation was communicated in WhatsApp to my representative. So therefore, the second writ was filed challenging this now. And then the second prayer was there because the first writ is also there. It's,
The order is passed on the same day.
It's of the same query.
No, it's on the same query. It's on the same query. I first filed this query, this one. After coming back,
No, sir.
let me.
It matters I could not, sir.
No,
Your query permit has been cancelled and the forfeiture security deposit is forfeited.
My lord.
So you have challenged in the first writ petition. What is the connected one?
Connected one was where I had prayed only the second. I had
To allow you to operate the mine.
So
relocate my query for the water.
I understood. So earlier you filed it for direction upon them to consider that application for modification.
Yes.
In the meantime, they issued the
So
letter of cancellation, which you now challenge in the first.
That is.
So these are all connected.
These are all connected. The same query.
Disposed of.
It's the same.
In terms of the earlier, only disposed.
No, not. Both will be.
Both will be.
Great.
I may be pardoned to make mention, my lord. Today's item number 36.
Carry forward tomorrow, sir.
My lord, tomorrow, my lord. First item. This is a my lord, Sishu Bhavan matter. Item number.
I have one prayer, my lord.
Sir, let me carry that. Don't worry.
I want adjournment in item number 20.
Mr. Samantrai, can you not mention it tomorrow? When it is called?
The lordship, I can make it a mention.
So it will be listed from item number 18.
18.
18 onwards.